with the consent of other side,
Please bring your speaker down to your mouth.
with the consent of other side, I beg to mention item number 17, Lordship, for adjournment today.
Council Miss, what is your name?
S. Yasmin,
Yes, Yasmin,
for respondent number 1 to 3.
for respondent number 1, 2, and 3 with the consent of the other
My
side.
my lord, I am for the appellate.
As prayed for adjournment, learned council Mr.
B other.
B. Arab is present for the appellant. How many days?
It may be 4 weeks.
Okay,
Okay.
list the matter after 4 weeks.
Much
Item
obliged.
number 70.
17, 17. Much obliged.
May it please your lordship, I beg to mention item number 9. I have also taken the consent from the other side.
Hmm.
Kindly list the matter after 3 weeks.
I am for the appellant.
After 3 weeks,
After 3 weeks.
learned council Miss.
You, Roy,
Euro is present for the,
on behalf of my senior F. Begum,
is present on behalf of learned council Mr.
Miss F. Begum.
Or Miss F. Begum representing the appellants.
Yes,
Learned council Miss.
S. Todi for all the respondents.
S. Todi is present on behalf of all the respondents. As agreed by both the parties, list the matter on after 3 weeks.
much of
Item number 9, no?
item number 9.
Lordship, similar prayer for item number 23 as well, Lordship. The matter may be adjourned for the day, Lordship, and maybe
Learned
fixed.
council Miss, same.
Item
parties are same?
23, no parties are not
Okay.
same, Lordship. I am for respondents 1 to 3 here. We have-
Learned council Miss S. Todi for respondent number 1, 2, and 3. With the consent of the
Oh,
other
yes.
side, as prayed for adjournment, list the matter after 3 weeks.
3 weeks, Lordship. Obliged, Lordship.
May you very please your lordship, I beg to mention item number 19 with the consent of the other side. It may be listed on 26th. I've taken consent for the
26th, okay. Learned council Mr.
G Kaushik for ours.
On 27th, 6th, on 27th.
27th, the council has told he'll not be any date on the first week of June. Then.
First week of June, 3rd June. Learned council Mr.
G Kaushik for ours and so on.
G. Kosik, on behalf of learned council Mr. R. Sensor representing the petitioner with
Petition.
consent of the other side has prayed for adjournment, list the matter on 3rd June.
Obliged.
May I please, Lordship?
It was item number 19.
19.
Lordship, I would beg to mention item number 14 with the
14.
consent of the other side for adjournment.
Learned council Mr.
Wasim Haq on behalf of Mr. A. Sattar.
Wasim Haq on behalf of learned council Mr. A. Sattar representing the respondents with the consent of the other side.
for the appellant, lordship.
Has prayed for adjournment, learned council Mr.
B Devi, lordship.
B. Dairy is present for the appellants, list the matter after 3 weeks. Okay?
Obliged.
Please, your lordship.
Hmm.
Item number 20 can be made, get a matter may be fixed at 2 PM.
Yes, can be.
Mass obliged.
Item 1 and 2.
May please, your lordship. So regarding the item number 1, my lord, as for the instruction of my client, my lord, I want to withdraw this petition. your lord.
Learned council Mr. F. Hussain has prayed for withdrawal. Learned additional PP Mr. D.P. Goswami is present for the respondent state. Petition is dismissed on withdrawal.
Obliged. Lordship, in item number 2, lordship, in this case, charge sheet has been filed. So therefore, we are withdrawing the case.
Learned council Mr.
PJ Das.
PJ Das has prayed for withdrawal. Learned additional PP Mr. D.P. Goswami is present for the respondent state. Petition dismissed on withdrawal. Item 3.
Lordship, this bail petition was earlier rejected by this report. But later on, the court case was granted with bail in the same case. So I have annexed the order passed by your lordship.
See, this is a bail application for NDPS case because
Yes.
he's standing on the other side. So I'm sure it's an NDPS case. So let us call for the trial court records. We'll need the trial court records. A scan copy, so you won't take much time.
Actually, yes, that may be required, but I am on the ground of
This is a
long
NDPS
incursions,
case.
yes.
I understand. NDPS case.
NDPS case.
Yes.
but long-
Doesn't matter. Long incarceration doesn't matter.
And the scanning, scanned copy is called for in another case, which is listed tomorrow before court number 3.
Okay.
So that might be available
We'll
by,
call for tomorrow. Okay.
okay,
But as I have rejected, so I will need the scan copies.
right.
Lordship, we need time to file our objection. 3-4 days, Lordship.
Since they have already objected and my ground is same, your honor.
They will object over and over again. Learned Counsel, Mr.
B Burman.
B. Burman, is present for the petitioner. Learned Counsel, Miss M.
M.
Dekka, is present on behalf of Learned Standing Council, NCB, Mr. S.C. KL, and has prayed for time to file their objection. Meanwhile, call for the scan copies of the childhood record along with the scan copies of the CD. Please the matter of 22nd.
Maybe tomorrow,
No,
maybe because the
not,
scan copy.
not possible, not tomorrow. Let them file their objection, 19 May, 19 May.
Highly obliged.
Item 4.
May please lordship. My lord, the so case lordship.
Notice.
Notice may go.
And earlier rejected lordship.
Yes, lordship.
Learned
I'll-
Counsel, Mr. M. H. Ahmed is present for the petitioner. Learned additional PP, Mr. D. K. Goswami is present for respondent state. Respondent number 1, no?
My lord, Two respondents,
State is
my lord.
Respondent number 1?
my lord, here in my lord, two respondents, private respondent, 2 and 3 lords.
That is one.
Okay.
State is.
Meanwhile, petitioner to take steps to issue notice to respondent number 2 and 3 returnable on 26 May, all
Lost.
right? Meanwhile, call for the charge sheeted or investigation is going on?
Investigation, AB.
Under investigation lords.
Huh?
Under investigation lords.
Meanwhile, call for the CD. List.
Obliged.
Meanwhile, call for the CD holder as well.
Obliged.
Item number 5 for orders.
Lordship, Lordship, matter be taken after some time, my senior is in other.
Okay. Item number 6.
May it please your lordship, let this matter be fixed for admission on a short date as Mr. D Chakravarti is out of station.
My lord, the matter is an injunction appeal. I am for the defendant, appellant before your lordship. Plaintiff was paid for an injunction, injunction was granted. Our construction has been halted, so there is some urgency in the matter, but my learned friend somehow is out of station today. Lordship may kindly fix it on 22nd
For admission?
for, appeal has already been admitted. So,
Appeal is made, so
Appeal
fix
is
it for
admit-
hearing there.
my lord,
Do we need the LCRs?
LCA is not necessary, it's only injunction appeal. Lordship may simply fix it on 22nd. Lord, that day, an endeavor shall be made to dispose. This is only injunction matter, my lord. 22nd.
Learned Counsel, Learned Senior Counsel, Mr. D. Muzumdar is present. Learned Counsel, Miss,
D Chakravarti.
Mrs. D. Chakraborty has paid for adjournment. Please the matter on 22nd May. Item number 7. Item 7. Accommodate hold. Item number 8 for hearing.
Lordship, matter I pass for time me, your lordship. My seniors in the legs and the court number 1, your lordship.
Item 10 for hearing. Item number 10. Only dismiss to be. Item 30. 11. Item 11.
May I please your lordship, I am appearing on behalf of the appellants, my railway appellants, my lord. The last check is on confusion and errors, whether I will challenge this whole entire judgment or not. Then, my lord, the appeal was drafted by the another railway advocate, my lord. Therefore, it was handed over to me. I was not acquainted with the actual facts, my lord.
Okay.
Later, I intimated the railway and they have made clarification, recent clarification that I have to challenge the entire judgment. So, my lord, and they have given me this railways record, my lord. So I need time, my lord.
Lordship, here the issues which was raised by the Railways Lordship, that both the issues were covered by the decision of the Honorable Supreme Court. And there was a admission from their side, Lordship, with regard to the relief, Lordship. So as such, Lordship, I request you to kindly fix this matter in the month of May, Lordship.
No, my lord, in the month of May, large number of cases has been fixed, my lord. In the 20th, 23rd and 27th, 25th, number of cases are fixed, my lord. So it is my humble prayer, my lord. It may be fixed on 3rd June or 5th June.
Let it be on 3rd June, Lordship.
Bless your lordship.
Item, item 10 negative. 11, 12. Learned Council, Miss U Chakraborty.
Chakraborty, Special Senior Railway Council, my lord.
Learned Senior Railway Council, Miss U Chakraborty has paid for adjournment as the railways have preferred to challenge the entire impugned judgment. Learned Council, Miss KP Mohsen.
M. Sharma
Miss M. Sharma
for the respondent.
is present for the respondents. And has raised objection. However, this matter on 3rd June.
Oblige your lordship.
Obliged.
Item 13, out for interest of justice leader.
My lord, I am for the respondent, my lord.
Insurer
No, my lord, same railway matter, my lord.
or railway matter, okay.
Yes, my lord.
What about the,
My lord, he is problem.
why, I think it's too early in the morning. Nobody has turned up. What's wrong? 4 or 5 cases we have called, nobody has turned up.
My lord, maybe fix on fifth, my lord, along
Yes,
with the.
yes, I'll fix for interest of justice, I'll fix it.
My lord,
Let me see if they are defaulting every day, then you can dismiss it also.
no, my lord, they have
Not required.
appeared in, they have
Okay,
appeared, my lord,
okay, okay.
in the. So, when I've been dismissed.
No, then again, it will get
Yes,
prolonged, it will
they
get
will file.
procrastinated.
Yes.
Again, they will file for vacation. Item number 13, no?
Yes, my lord.
Item number 13. But appellant is not represented. Learned Counsel, Mr. B. Sharma.
Z Goswami, my lord.
G. Gusma is present for the railways.
Yes, my lord.
Learned Senior Railway Advocate.
No, my lord, railway advocate, my lord.
Learned Railway Advocate, Mr. G. Gusma is present for the railways. For the interest of justice, list the matter on date of the death. 6 June. 5th June.
Deeply.
Item 10.
10, okay, yes, 10. We were waiting.
Item 10.
Other side is not present.
My lord, I am the legal aid counsel. Earlier date, my lord, so many date the learned counsel of the respondent is absent. Even then his name was in the cause list. And
Just a moment, huh? Item number 10, no?
yes, your lord,
Always, they are always absent.
you are absent, my lord. So many advocates they are, my lord. One,
Their names are all reflected. And
yes,
how many respondents we have in this case?
5 numbers of advocates, my lord. A. Ali, N. M. Decca.
Respondents are more than the advocates are more than the respondents.
Already appear, they were earlier appear, my lord, all the respondents, my lord. Respondent number 4. 4 numbers of respondents. 2 is my lord respondent and my lord dependent number and pro forma.
Advocates are more than the respondents, no? But still they are not appearing. Even then they are not appearing.
Service is completed, a respondent advocate is appeared earlier.
Appellant 1, 2, respondent 1, 2, 3. 4 respondents. Again, we can take up the hearing. There was an order last time. In the event of non-representation of respondent authorities on that day, an appropriate order shall follow. So we will take here, we'll take up the hearing.
Hearing, my lord.
You place a submission.
My lord, this initially, my lord, earlier I filed the title suit, page number 46. Page number 46 is the file title suit for recovery of first permanent injunction and first possession. In the plain, my lord, this schedule number A is the 1 kata land and B is the 15 lessa of land forcefully occupied by the respondent. Thereafter, after receiving the summon, the respondent, my lord, could not appear. And my lord, this learned trial court passed the
Which respondent could not
order. My lord, this 46 is the plaint of the title suit.
46.
That title suit, my lord, the defendant number 1 to 4 and pro forma defendant number 1 to 22.
Yes.
After receiving the summon, my lord, the respondent could not appear. Thereafter, my lord, this ex parte order passed, page 36.
They are always not appearing.
36.
From the first instant.
In the said order, the defendant did not appear in the suit after service of the summon and the suit proceeding ex parte.
Page
The-
36,
33.
page 33.
33 is the, my lord, learned trial court ex parte order in favor of me. I am the plaintiff.
Okay.
And after 4 PW is examined, thereafter pass the order. Thereafter, the defendant filed the title appeal. Title appeal, my lord. Page 10, my lord. Title appeal, page 10, 2/2015. In the title appeal, my lord, this respondent, only for, my lord, 2 respondent mentioned, my lord. Other, my lord, 4 and, my lord, pro forma 1 to 22, not party in the, my lord, title appeal. As far as plain, my lord, page 10, my lord. Earlier, my lord, respondent 1
The
to 4.
present respondent, pro forma respondent 3 and 4 are not were not parties in the title appeal.
Title appeal, my lord, the title appeal, my lord, is not include, my lord, only 2 respondent in.
Yes, yes.
Thereafter, my lord, this title appeal passed the order, page 17. Page 17 and on the ground, my lord, on the ground that, my lord, the sale deed was not proved by the, my lord, plaintiff, my lord. And to ground, my lord, the ex parte to early stage and settle the matter outside the court. That is the 3 ground. He filed the, my lord, appeal, and on that ground, my lord, this honorable, my lord, this learned trial court, appellate court, my lord, passed the order against me and set aside the, my lord, impugned order, not remanding the matter before the learned court for fresh trial after appearing the both the parties. Thereafter, I filed this second appeal before this honorable.
Okay.
And my ground, my lord, this appeal, first appeal, my lord, the appellant, my lord, could not annex the 2 numbers of main defendant and pro forma defendant could not annex. And my lord, this was ground, my lord, this at the early stage, my lord, it is denied, my lord. And my lord, he says, my lord, this, my lord, settlement outside the court, that is denied by the, my lord, plaintiff, my lord. And he intentionally not appeared. And my lord, this held it, my lord, this plaintiff purchased the land 1 kata, my lord, by register sold it and certified copy proved by this learned trial court. My lord, the learned appellate court, first appellate court, is not opportunity to remanding or to have been remanding the matter, and while both the parties are appear and fresh judgment was passed, that's not ordered by the learned first appellate court. For the learned appellate court committed a serious error of law in reversing the and setting aside the well-reasoned judgment and degree of the learned trial court. Well, Exhibit 1 is the copy of the registered sale deed was admitted in evidence without any objection, and therefore the learned appellate court erred in law in not applying her mind to the pleading and evidence on record, as also not considering the materials and relevant piece of evidence on record. My lord, the plaintiff examined himself PW1 and other three witnesses, PW2, 3, and 4. Plaintiff marked and proved exhibit 1, 2, 3, 4. The learned below failed to discuss the consider above the oral and documentary evidence, and therefore the judgment appellate court is vitiated by non considering the materials and relevant evidence on record. And my lord, this learned plaintiff exhibit 1 as per section 67 Evidence Act, my lord. So the substantial portion of law, my lord, whether the learned appellate court was right in the holding that the suit of the plaintiff is not maintainable, whether the learned appellate court error in law without formulating any point for determination or without discussing any evidence on record in the appeal in accordance with the order 41 rule 31 of the Code of Civil Procedure. The exhibit sale deed is a, my lord,
Yes,
It
a
is- it is-
substantial question of law framed on 11/1/2018.
sale deed, my lord.
Yes, yes. Okay.
Register for 4/5/2005 by registered sale deed 23 and obtaining a delivery of possession. Registered sale deed, there is no any disputed, my lord, this he purchasing the land. And he himself, my lord, this certificate copy he is exhibited. And only mutation order was passed his possession. When the defendant, my lord, when the plaintiff file another title suit 162/13 before this munship for recovery of first possession after receiving the summon by the defendant, thereafter forcefully possession 15 lesa out of 1 kata of land. So, my lord, I am the poor person, my lord. And, my lord, I am residing this house. If the, my lord, house is repairing, my lord, by the plaintiff, is always, my lord, sitting and my lord, and is not repairing my house, my lord. Kindly see, my lord, this photocopy of the plaintiff, where he his house, my lord. When he, my lord, for repairing this house for any season, my lord, the defendant, my lord, forcefully, my lord, torturing, my lord, and my lord, the plaintiff, so many case affair by the learned, affair by the OC, my lord, no action against, my lord, the defendant. He is the, my lord, manpower person. So, my lord, on that ground, my lord, this is so many date is absent by the learned at work, defendant, my lord. The impugned order said, my lord, otherwise reverting the matter to the learned trial court for fresh trial, my lord. In the meantime, protection may be given. My lord, my house, it is the, my lord, this very, my lord, poor person. He is not, my lord, even then his report for repairing his house at this stage. And his purchase of, my lord, 1 kata of land, my lord, that is the admitted, my lord, he's purchased the land, my lord, by registered sale deed.
Stay has been granted in this case, no?
No.
No. Okay, then I'll reserve for judgment
Fine.
and order.
Deeply obliged.
I'll give the photograph. Our learned counsel, learned legal aid counsel, no?
My
Right. Oh.
our house is repairing is very necessary, my lord.
Hmm.
That observation is your lordship.
Okay, I'll write it.
Fine. LCR also this.
LCR, we have the LCR.
Yes.
LCR was called
Yes.
in the year 2018 itself. Our learned legal aid counsel, Mr. Z. Hussain, for the appellant. The respondents are not represented today. Earlier, the respondents were absent without steps. Then an order was passed on 8/4/2025 that in the event of non-representation of the respondents, an appropriate order shall follow. Thereby, after hearing the learned counsel for the appellant, who has raised objections stating that several that on several dates the respondents were not present, and on several dates adjournments were also obtained by the respondents. So, this case is fixed for this case is reserved for judgment and order.
Deeply obliged.
Orders.
Do argument to paste to you.
May I please, your lordship? The honorable court directed the appellant side to submit the translated copy of the first examination part, lordship, filed order dated 9/5/2024. Accordingly, that has been submitted, lordship. As per office note dated 5/5/2025, lordship, the registry has received the translated copy.
So we'll fix it for hearing that.
Yes.
For hearing.
Lordship, any date after summer vacation, lordship, if possible.
For summer vacation. Yes. What about you? Summer vacation, after summer vacation,
July.
mid-July. After summer vacation will be mid-July.
Proceed.
A date may be fixed, lordship. Otherwise, it will not come. That is in the last tag, Lordship, it is. In the record, it is in the last tag.
Last date, no?
The tag, Lordship. The translated copy
Okay, okay.
with the note, translated copy.
Oh, yes.
I have supplied a copy to the learned council for the respondent already.
Learned Counsel, Mr. UB Sharma
Yes, Lordship.
is present for the appellants. Learned Counsel, Mr.
You do.
U. Doctor is present for the all the respondents. It is submitted that translated copies of the questions of witnesses,
Cross-examination part of
Cross-examination.
the witnesses.
cross-examination of the witnesses have been furnished to the respondents.
Yes.
Which is tagged along with in the record. Seen the office note dated 5/5/2025.
5/5/2025.
List this matter on 14 July, 15 July, 15 July
Yes.
for hearing.
Lordship, no, it may be on 17.
17 July for
7.
hearing.
Highly obliged, Lordship.
Agriculture 7 for hearing positively.
For orders. My pleasure, Lord. There is a delay of 129 days in filing the appeal against the criminal revision number 33, 2022 passed by the learned session judge Jorhat.
Item number,
Seven, Your Lordship.
MAT appeal.
Yes.
This is MAT appeal.
It is not, should be, because it is originally tried for, they have filed an application on, we have filed an application on the 125 CRPC for maintenance. Against that, they have come for revision. Before the, under
Yes,
section
yes.
300, before the session code.
125.
125 against, they have come for revision against the session code.
Yes.
Again, now they have come for matter bill under section 19. This is not maintainable because against there is no family code in Jorhat. How can it be maintainable? I have stated in paragraph 2 of my petition. Paragraph 2 of my petition. You just take what.
Lordship, we have while filing the appeal, we preferred in another provision, but the registry told that it cannot be filed under that provision, matter appeal should be filed. That's why we filed again.
There is a confusion here.
Yes, Your Lordship.
I've noticed this confusion. So somebody will say you'll have to file under the family.
482 is, this will come under
Somebody will say you'll
482.
have to
Yes.
file under the Hindu.
We have
Parliament.
changed the
No, I'm
petition.
sorry, under the, this will come under which act?
482.
CRPC.
482 you have to come.
But
Because-
here we are on the delay part, Your Lordship.
You-
And
when
the appeal is the
when main appeal is not maintainable, there is no meaningful condition of the delay. Because your lordship has seen the provision of section 19. May I read?
Yes, yes, can read, just a moment, it doesn't family court act on it. It is relating to family court.
Yes, sir.
Jorhat doesn't have a family.
Yes. Only from the order of the family court, appeal lies under section 19. They should have come under section 482. In a public court, because they have also already have the availed the revision under
Yes.
as a session court. So second revision petition doesn't lie, and only in the rest of their case, they have to come under 482. So this appeal is not maintainable, and there is no question of continuing delay. When I mean appeal is not maintainable.
Jorhat doesn't have a family.
Yes, Your Lordship.
But this, it bond court isn't family court.
In another court, Lordship.
We'll take it after some time.
Lordship.
Item 16.
May it please your lordship. My senior counsel is also in a part heard matter.
We'll take it up after some time.
Obliged.
Lordship, kindly matter may taken after some time.
Okay.
Seniors in lake.
Item 22 Duta Bazaar. Huh? Oh, they have asked for.
Yes,
No,
my lord,
Lordship.
we are not informed that they are going to take
No,
time, my
no,
lord.
they have asked to place the matter at 2.
I am for the petitioner, my lord.
No, Lordship, they are for the petitioner, I am for the respondent. We are seeking an adjournment today. The conducting counsel is unavailable.
Okay.
Yes, sir, my lord, there is an urgency in the matter as writ has been issued, my lord, in this matter, and we have given time till 15. So, my lord, kindly matter may fix tomorrow at 2, my lord.
Okay. Learned counsel, Mr.
B. Sekya, my lord.
B. Sakia has prayed for adjournment. With the consent of the other side has prayed for adjournment, list the matter tomorrow. Day after tomorrow.
My lord, then at the top of the list, my lord, because my
Tomorrow
lord,
is not a hearing day.
my lord, on 15 at top of the list, my lord,
At 2 p.m.
2 p.m.
At 2 p.m. Not at top of the list because you are the one who is seeking adjournment.
No, no, my
No,
lord.
no,
Here-
Lordship, we are
Oh, you
seeking
are
the
seeking-
adjournment. Yes, Lordship.
At 2.
Much obliged.
Apology, my lord, for the interruption. In respect to item number 13, Lordship, at that moment I was in legs at court number 11. Lordship, if my appearance may be recorded, Lordship, they will.
Item number 13. Could you be present?
D. Rati. Much obliged, my lord.
নাই পাছত গোটেইখিনি একেলগে হেৰি কৰি দিম ডেট দি দিম যদি নাহে আৰু
My lord, this compensation is claimed under section 166 of this case, my lord. Judgment and award dated passed dated 15/5/2017, my lord.
Let the other side come. I think they will come because last time they were the ones who have taken adjournment.
Oh,
Mr. Biswakarma appearing on behalf of the respondent
otherwise this is small ground, my lord.
with consent of the other side has prayed for listing the matter on 13/5.
Oh,
Let them come, we'll wait for some time.
Okay.
I don't know why early in the morning, everybody is not willing to come and place their matter, God knows. How many?
Hmm.
Then I'll come at 2. I'm sorry. I'll come at 2.
oh, let me.
Ah. El Sarma is present for the appellants, whereas the respondents are not represented. For the interest of justice, list the matter on
Any day, my lord.
after 1 week. After 1 week.
Oh, bless me.
Item number 8. Yes.
May it please your lordship.
Yes.
This second appeal, my lord, preferred by the plaintiff appellant, my lord. The plaintiff suit was decreed first, my lord. And then, my lord, the opposite party filed an appeal and appeal was allowed,
You'll continue with the argument.
my lord.
You'll argue.
Yes, my lord, I am ready to argue, my lord.
Argument lamba ho sakta. It will be a long argument, no?
It will take time, my lord.
Yes.
Hmm. The plaintiff, my lord, filed a suit, my lord. Plaintiff suit was, my lord, your lordship, my lord, I will start from the suit was decreed. Suit was decreed, my lord.
You are a plaintiff or the?
I am the plaintiff, my lord. Plaintiff suit was decreed and defendant filed an appeal and appeal was, my lord. Appeal was allowed and against that the second appeal is preferred, my lord. There are two or three, my lord, two substantial question of law, my lord, formulated, my lord. I'll come to that, my lord. Before that, my lord, I'll go to the, my lord, judgment of the Lana Trial Court, at page 8, my lord. Page 8, my lord.
Page 8.
Page 8, my lord. Suit is for declaration of recovery of cash possession by declaring the mutation and partition over the dated so the sale deed illegal and not operate in the law. Plaintiff case in brief that amendment that the plaintiff and the former defendant number 11 and 14 are legal hire of the late Mona Soikia who purchased a plot of land measuring 1 biga 2 katha, 2.5 lessa covered by DAG number 698 BPM from 90 and described in Sidel. A from Haguni Sutia by executing a registered sale deed on 42352708. But prior to the execution of the said sale deed, Haguni Sutia instituted a 3S number 64 of 62 against the Niren Soikia, Sadori Hoikia, Mona Soikia, and Bothai Kolita, claiming half share of the land measuring 2 big 4 quarter 5 less of PPW number so and so. Suit was decreed in favor of the Phaguni Sutia, Sadori Sutia, and sister Phaguni Sutia by mistake sold the entire land to the dead Lokthai Kolita Nitai on 11/1/1951, who in the turn sold the defendant number 1 on TS number 64 or 62 Noran Soikia on 6/4/6/1956. But Phaguni never sold her share of the land to anyone, and hence the TS 64 of 62 was instituted. During the pendency of the TS 64 or 62, Noran Soikia was defendant number 1 of TS 64 of 62, executed the sale deed and transferred illegally entering entire land to the 1 biga 3 katha 14 lessa under DAG number 698 PP number 159 favor of the George Beck, father of the present defendant, without informing the Phaguni Sutia or the court. Hence, the plaintiff pleaded that the sale deed executed by Noran Sutia in favor of the George Beck is liable to be cancelled, and the Noran Sutia has no right, title, and half share of the said land. Therefore, George Beck muted his name as per order of the Sitha mutation separate patta number 627, that is made illegally as per order passed in Sitha dated 18/10/1963. The mutation was passed illegally without observing the required procedure as regard under Assam Land and Revenue Regulation. Mona Soikia, father of the plaintiff, after purchasing the suit land from Phaguni Sutia, took possession of the said purchased land and 1 biga 2 quarter half lessa under a DAG number 69669. But after the death of the Mona Soikia, the defendant, taking the advantage of the absence of the plaintiff, illegally occupied 4 katha 6.5 lessa under DAG number 698, periodic patta number 159 on about 15/10/1980, constitute a Pakka building prescribed in Schedule B referred as Switzerland. Hence, this suit, as a defendant number 1 expired, hence the defendant number 2 to 7 by filing a written statement contested the suit. Defendant averted that the suit barred by section 140 of the Assam Land and Revenue Regulation. Defendant contended that their predecessor in interest lawfully purchased the plot of land measuring 1 biga 3 katha 13 lessa on 6/2/1961 from Niren Soikia and sale deed who neither illegal. Defendant contended that the mutation and partition were not illegal and the court was no jurisdiction to adjudicate the operation of the partition. Defendant during the divided any part of the suit land to the vacant, contended that the petitioner was legal and valid and that plaintiff has no right interest over the suit land. Defendant denying all the allegation of the plaintiff, paying for a dismissal of the suit. The former defendant number 8 and 9 filed a written statement when he admitted that the suit land was purchased by the plaintiff father from Phaguni Sutia. Defendant number 8 and 9 admitted that they are not in possession of the suit land and their father died long ago. Hence, they do not know what gave in respect of the suit land. As the plaint was amended, hence the defendant number 2 and 2 to 7 filed an additional written statement wherein it contended that they were to the pleading as incorporated in the body of the written statement filed on 7/3/2000 and that the suit has barred under the law of limitation as well as barred under the Assam Land Revenue Regulation is not barred for non-joinder of necessary party. Upon pleading, the following issues were framed by the learned predecessor. Whether the suit is barred by section 154 of the Assam Land and Revenue Regulation, whether the suit is barred by limitation, whether transfer made by the Naren Soikia for a land measuring 1 bigha 3 kata 13 lessa under DAG number 169 covered by Pata number 159 in favor of the George Beg is illegal and void, whether the plaintiff has a right to challenge the partition and mutation alleged before the court, whether the plaintiff has a right, title, and interest over the suit land, whether the plaintiff is entitled to get decree as paid for. During the course of hearing, plaintiff examined 3 witnesses, but evidence of defendant number affidavit on PW3 Dulu Bora was not accepted by the learned predecessor. Plaintiff exhibited 3 numbers of documents. Defendant examined 1 witnesses and exhibited 26 numbers of documents. Heard argument for the learned counsel for the both parties is peruse the material available on record, decision and reason thereof. Issue number 3, PW1 Dharmeshwar Bora deposed that on 25/8/71 his father bought 2 bigha 2 katha and 2.5 lessa land from 159 Pata DAG number so from Sarigaon Moza village. The purchase was done from owner of Phaguni Sutia, who got the decree from municipal court in TS 64 of 62 against Niren Soikia and some other. The land which Phaguni Sutia obtained for TS 64 of 62 suit in the suit land, after obtaining the decree, Phaguni sold the land to his father. But Niren Soikia sold the same land to George Beg, who after some days took possession of the land. After the decree of TS 62 of 64, George Beg did Siddha mutation of the suit land. So their father took possession of the suit land on constitute the house, but 25 years ago, George Beg had by disposing them took possession of the house constituted by the Naren Soikia. The suit land, PW1 deposed that the suit land is vacant and the defendant has not title or possession over the exhibit 2. It is the registered sale deed executed by Phaguni Sutia in favor of the Mona Soikia. Exhibit 2 is the certified copy of the order and judgment of the TS 64 of 62. Exhibit 3 is the certified copy of the Jamabandi. PW2, Deben Gogoi in Sorkari Gaon of Mount Gaon deposed that the Phaguni Sutia in TS number 64 of 62 claim her half share of his entire land of periodic Pata number 159 got a decree in favor. Thereafter, Phaguni sold 1 bigha 2 katha 2.5 lessa of land covered by DAG number 698 of the plaintiff's father to the plaintiff's father. But during the pendency of this TS number 64 of 62, the defendant Niren Soikia sold their entire land measuring 1 bigha 3 katha under DAG number 696 to George Beg, the father of the present defendant. But Phaguni never sold her share to the George Beg as per the judgment of TS number 64 of 62. Naren Soikia has no right over the half portion of the land sold by him, the George Beg. And after the death of Mona Soikia, defendant illegally occupied the 4 kathas 6.5 lessa of land of the construction of by Pakka building half portion of the suit land, but the other half portion of the 4 katha 6.5 lessa is lying vacant. PW2 also deposed that George Beg mutated his name in the Patta and partition on his share, and new Patta number 627 is obtained. DW1 Mirza Beg deposed that the 622 to 1661, his father let George Beg purchase a plot of land measuring 1 bigha 3 katha 13 lessa by registered sale deed covered by Pata number 404 number DAG number 66 situated in the Mount Gaon. And thereafter this father has continued the possession of the said plot of land till the death, and thereafter the defendant were in continuous possession of it. Further, that the land was mutated in their father's name, and after this father's death, this name their name DW1 deposed that their fathers purchased the disputed land prior to the institution of title suit number 64 of 62. DW1 contended that the learned Mona Soikia did not purchase the land covered by Pata number 627 and aver that no part of this pattern number 6 to 7 vacant exhibit A revenue received, but exhibit 2 Java money copy, exhibit C sale deed, and dated 6/2/2061. Exhibit 2D are revenue paying receipt. The cross examination in cross examination DW1 deposed that in 698 Dak there are 1 bigha 13 katha, 3 katha 13 lesser land. In half portion of the land, the dispute has arisen. DW1 averred that the land which he is free from dispute DW1 has his house where has the other part is vacant. DW1 also admitted that in TS number 64 of 62 Phaguni Sutia claimed half portion of the land covered by the pattern number 404 and Dak number 6566. DW1 also admitted that the Phaguni Sutia got the decree. DW1 also admitted that after the decree Phaguni sold her half. So sold half of the 1 bigha 13 lesser of her share to the Mona Soikia, that is from Dak number 698, by registered sale it on 25/8/1971. For apprise the 11th portion of the evidence and record, it is clear that the plaintiff father Mona Soikia purchased a plot of land measuring 1 bigha 2 kotha half 2.5 lesser covered by Dak number 696/698 periodic pattern number 159 from the Phaguni Sutia by registered sale in the year 1971. After she got a decree in her favor, yes number 62 of 64, confirming her possession in share of the land. Pursued the exhibit 1 where it is written that exhibit 2 katha 16 lesser of the land covered by Dak number by 696 new 65 old Dak pata and 4 katha 6.5 lesser of land covered by Dak number 66 old 698 new was sold to the plaintiff father Phaguni Sutia. Indeed, it is also admitted fact that the Narayan Soikia sold 1 bigha 3 katha 13 lesser of land covered by pattern number 404 of Dak number 66 to the George Bag on 6/2/1961. That is prior to the decree of TS number 64 of 62. It appeared that the total land of Dak number 66 in 1 bigha 3 katha 13 lesser as per the decree of TS number 62 of 64. Phaguni was entitled to half of 1 bigha 3 katha 13 less, that is 4 katha 6.5 lesser of Dak number 66, and this 4 katha 6 lesser Phaguni sold to the Mona Soikia. And after the decree of TS number 64 of 62, selling of this entire 1 bigha 3 katha 13 lesser of land to Dak number 66 old and new 691 to George Bag was illegal, as Phaguni is also entitled to her share. So the learned counsel for the defendant contended that the sale did by Narayan Soikia in favor of the George Bag has not been challenged, but it cannot nullify the decree of TS number 64 of 62. Hence, this agreement of learned counsel for the defendant does not hold any merit. In view of the above discussion, I find the finding of the mine. I am the opinion that the transfer made by the Narayan Soikia for the land measuring 1 bigha 3 katha 13 lesser father under Dak number 698 covered by petition in favor of the George Bag is illegal and void. Accordingly, this issue was decided in affirmative in favor of the plaintiff. Issue number 4, in view of my finding and decision in this issue. Number 3, I find that the petition and the mutation by the defendant number 1 were not in valid one, and the plaintiff has right to challenge the petition and mutation. Accordingly, the issue was decided in the affirmative. Issue number 2, Article 65 of the Limitation Act lays down that the title suit is not at all barred by limitation because there is no limitation but a suit based on title. Further, defendant also could not show how this suit is barred by limitation. Accordingly, this issue was decided in negative. Issue number 5, in view of my finding on issue number 3, it has already been established that the Mona Soikia brought the suit land from the Phaguni Sutia, and after Mona Soikia plaintiff got the suit land by way of an inheritance being son of the Mona Soikia, hence the plaintiff has a right title and interest over the suit land. Accordingly, this issue was decided in affirmative in favor of the plaintiff. Issue number 1, though defendant has contended that the suit being the respect of particular partition granted under the provision of the Assam Land and Revenue Regulation, this suit is barred by under section 159 of the land regulation. But on perusal of the record, it is seen that it is a suit for declaration of right, title, and interest of the plaintiff over the suit land, and for declaration of this mutation and partition under the order passed by the learned SDC, Jorhat is circling illegal. Now, hence the deal with the claim of person to perfect partition or imperfect partition. Hence, the claim of the plaintiff cannot be brought under the ambit of section 150 of the Assam Land and Revenue Regulation must be adjudicated under the civil court. Accordingly, this issue is decided in the negative. Issue number 6, in view of my finding and discussion in the above discussion issue, I am the opinion that the plaintiff is entitled to decree as paid for. Accordingly, this issue was decided in the affirmative order. In the result, the suit decree on contest, the suit titles right, title, and interest of the plaintiff over the suit land is declared, and khas possession of the suit land be delivered to the plaintiff by demolishing the portion of the house standing on the suit land by evicting the defendant from suit land. Also, the mutation and partition order passed by the SDC Jorhat is showing so illegal. Defendant are permanently injunction from any permanent construction on the suit land. No cost allowed.
Yes.
So that was the my lord, suit was allowed. Against that, my lord, defendant, my lord, filed a appeal, my lord. In various ground, my lord, their main ground was that, my lord. I have seen the memo of appeal, but although it is not available with me, but it is in the record, my lord. Their main ground was, my lord, for appeal. The first appeal was that, my lord, it is barred by section 154 of, my lord, Assam Land and Revenue Regulation. So now I read the, my lord, appellate court judgment, my lord. This appeal is directed against the judgment and decree passed by the learned. Page 21, my lord. Page 21, my lord.
Yes.
This appeal is directed against the judgment and decree passed by the learned Munsif number 1, Jorhat in PS number 20 of 2006. The learned trial court decreed the suit of the respondent by impugned judgment on being aggrieved by the aforesaid judgment on decree. The defendant number TS number 20 of 2000 filed the instant appeal on the various grounds incorporated in the memo of appeal. My lord, it was filed actually in 1999, but subsequently it was renumbered as, my lord, 20 of 2006. They renumbered, my lord. So that is why here to the 20 of 2006. Filed against the instant appeal, various ground abandoned. In order to appreciate the appeal, the facts and the circumstances leading to the finding of the suit by the respondent required schooless consideration. Respondent case, the respondent in the suit is Sir Shri Dharmeshwar Soikia. He filed the suit against the appellant and the respondent and his two sisters, Senimai and Onu are children. Later, Mona Soikia, this Mona Soikia purchased a plot of land measuring 1 biga, 2 kata, 2.5 lessa, covered by DAG number 696 and 698 of the PP Pata number 159 from the Phaguni Sutia. Now came to the question of how Phaguni Sutia acquired the aforesaid land. This Phaguni Sutia and her sister Sadori Soikia inherited 2 biga 4 kata 5 lessa of land under DAG number 696 of Public Pata number 159 from their mother's late Kon Sutia. Thereafter, by mistake, Sadori Sutia sold the entire land to one Lathi Kolita Nafai on 11/1/2051. 1951. This act was Sadori Sutia caused Phaguni Sutia to institute a suit TS number 1964-62 claim half share of the entire land sold away by Sadori Sutia. If any be mentioned that on 4/6/1956, Nitai sold the land to Niren Soikia. Thereafter, TS 64/62, Niren Soikia was implicated as a principal defendant while delivering the judgment of TS 64/62. The learned trial court decreed the suit of Phaguni Sutia and declared the right over the half share of the land sold by Sadori Sutia to the Nitai. the learned court also directed that Phaguni City is be put in joint possession of the just possession of her shares along with the appellant Moirang Bez since the deceased. Miraj Bez and Miraj Bez in the plain respondent claimed that the judgment passed by TS 64 is null and void and there is not binding upon him. It has been claimed that during the pendency of TS 64 of 62, Niren Soikia sold their suit land to late George Beg, the predecessor of the present appellant, that means defendant. This George Beg even mutated himself in the record of right. Furthermore, the George Beg had suit land partitioned by an order of the Revenue Authority. The respondents stated that after passing the decree of TS 1964 of 62, Phaguni City sold her share of land to Mona Soikia, the father of the present respondent number 25 on 25/8/1971. With the aforesaid story of the land, the respondent paid for following relief: pair of a decree declaring the right title and interest over the plaintiff over the suit land. The passed decree for evicting the defendant from the suit land and for recovery of first possession of the suit land by demolishing the portion of the house standing on the land. Passed a decree of declaring the mutation and partition on order passed by learned SDC Johan East Circle is illegal and not operative in law. Pass a decree of permanent injunction restraining the defendant from constructing any permanent construction on the suit land. Pass a decree for cost of the suit and for any other relief which plaintiff is entitled to get under provision of law. Appellant case. The appellant Mirza Beg, Amzar Beg, Elizar Beg, Imli Beg, Blazer Beg, Sithala Beg, contested the case by their respondent by filing a written statement. Those appellants disclosed that their purchaser George Beg purchased the suit land from Niran Soikia on 6/1/1961 before institution of TS number 64 of 1962. On this ground, that the appellant claimed that the present suit is barred by law of limitation, referring to the partition order passed by the Revenue Authority. The appellant pleaded that the present suit is respondent is barred by under section 154 of the Assam Land and Revenue Regulation 2. The performer defendant Ojit Soikia and Pradeep Soikia, both are son of Niren Soikia, also filed a written statement. They stated that they have no possession over the suit land. There is no, those two performer defendants submitted that they have no claim over the suit land. On the basis of the alleged pleading of this pursuit, the Lana Trial Court settled the following issues. Whether the suit is barred by section 154 of the Assam Land and Revenue Regulation, whether the suit is barred by limitation, whether the transfer made by Niren Soikia for the land measuring 1 bigha 3 katha 13 lessa under DAG number 698 covered by PP Pata number 159 in favor of the George Beg is illegal and void. Whether the plaintiff has a right to challenge the portion and mutation of the alleged partition and mutation alleged before this court. Whether the plaintiff has a right title interest over the suit land. Whether the plaintiff is entitled to get decree of paid for. In course of the trial, the respondent examined 2 witnesses and the appellant examined the 1 witness. Thereafter, on the basis of the evidence on record and therefore considering the relevant portion of law, the trial court passed the impugned judgment and decree. I have heard the learned counsel for both sides. The learned counsel B. Soikia appeared for the appellant, submitted that the suit of the opposition party is barred for want of notice under section 80 of the CPC. The submission of the learned counsel was based on the fact that the circle officer Jorhat has been arraigned as a performer defendant in the suit. The learned counsel B. Soikia further submitted that the suit was also barred under section 154 of the Assam Land and Revenue Regulation. According to the learned counsel, the mutation order passed made by the Land Revenue Authority Act of the formation of preparation of the right of the record of right. The learned counsel B. Soikia seemed to be more particularly aggrieved while the learned trial court decreed the suit issue number 2 pertaining the limitation is negative. I have also heard the learned counsel for B. Goswami who appeared on for the respondent, the submission of Learned Counsel B. Goswami has nothing to write, home about. The Learned Counsel simply submitted that there is nothing in the judgment to learn the Learned Trial Court that required interference by the appellate court. After hearing the Learned Counsel for both sides, I have found that the Learned Trial Court did not frame a issue pertaining to the non-service of issue notice under section 140C3. At this stage, I found that this plea was not taken by the appellant in their written statement. Therefore, I have decided that the plea of the non-service of notice under section 80 CPCP does not require any decision, any discussion at all. After considering the submission of the Learned Counsel and material found before me, I have found that the suit of the respondent revolves around the question whether the suit of the respondent is barred under section 150 of the CPC. 154 of the, it is not CPC, that is my lord.
I know.
It is not
That's why I wrote
CPC,
printed.
my lord, it
Only
is,
that.
my lord, Land and Naval Legislation. A decision of the appropriate question Learned Trial Court settled the two issues, namely issue number 1 and issue number 2. Therefore, I shall take up the two issues together by they are absolute similar in nature. So I shall take up the other issue in their given order. Issue number 1 and 4. While filing the suit, the respondent paid that the mutation and partition order passed in favor of the late George Begg to be declared null and void under section 154C laid down that no civil court shall exercise jurisdiction in the formation of any record of right or preparation, signing or alteration of the document contained thereon. The Learned Counsel B. Saikia submitted that the mutation of George Begg and the partition of the suit land made by the revenue authorities cannot be challenged in civil court. Under the aforesaid provision of law, the Learned Trial Court held that the respondent paid for a declaration of his right, title, and interest over a suit land apart from the making the aforementioned pair. Therefore, the Learned Trial Court held that the suit of the respondent is not barred under section 154 of the Assam Land and Revenue Regulation 1986. It is true that the section 154 of the aforementioned regulation does not debar the civil court from entertaining the suit based on the title to the property. For a moment, I shall keep this point aside, deliberate upon another aspect of the case. At this juncture, I have decided to find out when George Begg purchased the suit land from the Narayan Saikia, had the respondent pleaded that the Narayan Saikia had sold the suit land to George Begg during the pendency of the TS 64 of 62. The appellant claimed that their predecessor, George Begg, purchased the suit land from Narayan Saikia before institution of TS number 64 of 62. They claimed that the George Begg purchased the suit land on the 60 to 61. The appellant proved that aforementioned sale deed as Exhibit C, it is registered sale deed, that is 6261. During trial of the case, the respondent Dharmeshwar Bora stated in evidence that the land which Phaguni got by virtue of their decree passed in TS number 64 of 62 was sold by Phaguni herself to her father Mona Bora. He further disclosed that the Narayan Saikia had sold his land to George Begg. On the basis of the sale, George Begg came to occupy the suit land. The respondent admitted that the mother of the Sadori sold 1 bigha 3 katha 14 lesa of land to Narayan Saikia. Accordingly, the respondent Learned Trial Court, while passing the decree on TS number 64 of 62, declared title of Phaguni over the land. According to the respondent George Begg, they came to occupy the suit land about 20 to 25 years back. George Begg also occupied the house of construction by Narayan Saikia. Thereafter, according to the respondent, this land is now lying vacant. The respondent further declared that the land which the stand adjacent to the suit land is now being occupied by the son of the George Begg, and his land has no connection with the suit land. This respondent denied having any knowledge if their mother of Sadori had sold the entire suit land to the Luthai Kolita on 11/1 1951. He also denied that having any knowledge that the Lutai had sold the sold land to Niran Soikia on 5/4/6/1956. Now I have found that the respondent denied the existence of the plea which they himself has taken in the plane. He also denied having any knowledge that George Beck had purchased the suit land from Noran Soikia on 6/2/1961. The respondent also denied having any knowledge of on 18/10/1965. The suit land was partitioned by the Revenue Authority, which gave birth to a new patta, that is PP number 627. This respondent admitted that no execution proceeding was initiated to execute the decree of TS number 64 of 1962. After considering the evidence of the parties, I have found that respondent himself denied his own pleading. Averting back to the point of law laid down by the section 154 of the Assam Land and Revenue Regulation, I have no doubt that it is proved with preponderance of the evidence that George Beck purchased the suit land before institution of TS number 64 of 62. The mutation of George Beck in record and registered as well as the partition of the suit land amount to preparation in favor of the record. Thus, a pair of challenging the mutation order of the partition order of barred under section 154 of the Assam Land and Revenue Regulation. The learned trial court committed an error while deciding these two issues in negative. At last line of the decision of issue number 4 is that trial court judgment shows that those learned trial court decided that issue in affirmative. Before that, the learned trial court held that the respondent has the right to challenge the partition and mutation in favor of George Beck. Thus, I have sufficient reason to hold that he was slip of pen and the word affirmative should have been word negative. With this aforementioned decision, I hereby answered both those two issues in affirmative. Issue number 2, I have already discussed here in the bed that fact that the George Beck purchased the suit land on 6/2/2061 suit proof. Article 65 of the Indian Act provided that the suit is for possession of the immovable property or interest thereof based on the title must be fall within 12 years where the possession of the defendant became adverse to the plaintiff. The learned trial court committed a Himalayan error while holding that the suit for the respondent is not barred by limitation as to the file the suit on the basis of his title. In this instead case, it has been proved that the George Beck purchased the suit land on 6/2/1961, not withstanding this fact that the respondent stated in evidence that he has no knowledge as to the George Beck purchased the suit land under circumstance. I hereby hold that the suit of the respondent is barred by Article 65 of the Limitation Act, thus issue of the answered affirmative. Issue number 3, the plaintiff disclosed that the Phaguni and Sadori inherited their land from their mother. By mistake, Sadori sold the entire land to Lathimai Kolita. Phaguni was Lomthai Kolita. Phaguni was entitled to half share of the land. Therefore, she filed a suit claiming her half share of the land. It may be mentioned that before filing the suit, Lathai had sold the land to Niran Soikia. The court decreed the suit in favor of Phaguni and thereby declared that the suit she is entitled to half share of the aforesaid land. The respondent claimed that during the pendency of the suit filed by Phaguni Sutia, Niran Soikia had sold the suit land to the George Beck. On this ground, the respondent claimed that Niran Soikia illegally sold the suit land to the George Beck. While deciding the foregoing issue, I have held that the appellant have proved that George Beck purchased the suit land on 6/2/2061 before filing of the suit by Phaguni Sutia. In spite of that the respondent stated in the evidence that he has no knowledge as to when George Beck purchased the suit land from Niran Soikia. The case record of the years 64-62 was called for by the parties concerned. I found that the learned trial court, while passing the judgment on TS number 64 of 62, directing that the Phaguni Sutia be put in possession of the suit land along with the George Beck. I am not sitting in appeal over the judgment passed in TS number 64 of 62. So I shall not deliberate upon the merit of the judgment passed by the in that case. But I must say that the judgment passed by TS 1964 is still in force, as there is no appeal was preferred considering the aforesaid fact. I hereby hold that the sale deed of the suit land Niren Soikia to the George Beg is not illegal and void. After recording of my disagreement with the learned trial court, I answer this issue negative. Issue number 5 and 6. I have taken the both those two issues together of they are absolutely similar in nature. The respondent is the son of Sadori Soikia. This Sadori Soikia sold the entire land which she had her sister Phaguni inherited from their mother. Phaguni Sutia had to file a suit for recovery of her share in that land. The suit of the Phaguni Sutia was decreed and the court declared that she was entitled to the half share of the land. Sadori Sutia sold the entire land to Lotmai and Lotmai sold to some of the Niren Soikia, who finally sold the land to George Beg. Thereafter, Phaguni instituted the aforesaid suit, but the learned trial court, while passing the decree in TS number 64 of 62, so declared that Phaguni was entitled to half share of the according land, further directed that Phaguni is put in possession of her along with the hire of the George Beg. Another aspect of the case described by the respondent is that Phaguni Sutia had sold her share in the land to his father. On this ground, the respondent paid for a declaration of his right title and interest over the suit land. The respondent stated that the evidence that his father Mona Soikia father after purchasing the land from Phaguni Sutia, a house over there, and George Beg illegally occupied that land with the house about 20-25 years ago. The respondent disclosed that the house constructed by the father of the suit land is still lying vacant, and the hire of the George Beg have constructed a RCC house over a land standing adjacent to the suit land. While filing suit, the respondent paid for a recovery of the suit land by demolishing a portion of the house situated on the suit land, leaving his aspect of the case apart. I find myself in a peculiar situation on the decree of TS 64-62 declared that the Phaguni Sutia has a title over a half share of the land which was sold by the Sadori. But the court further directed that the Phaguni was to be put in joint possession of her share of land along with her legal hire of the George Beg. There is no evidence on records to show that the Phaguni had and the hire of the George Beg partitioned their land between themselves, so that Phaguni cannot sell the portion of the land which she occupied. The judgment of TS 64 of 62 is still alive. The hire of George Beg also put the possession of the suit land. Thus, the title of the suit land never got transferred from Phaguni Sutia to Mona Soikia. Hence, I hereby hold that the respondent has no title over the suit land. I answer both the issue 5 and 6 in negative. After recording my decision with the decision of the learned trial court order, that being the position, this appeal is allowed. The judgment and decree trial court are set aside. The suit of the respondent is dismissed of the cause. Before parting in the record, I have intended to view of the respondent. I do not hesitate to state that the plaintiff is even extra the plaintiff himself is required to therefore I find that the entire plaintiff is a celebration of heedless places before the court to law past previous judicial time in center. I send down the copy. I give my that. So that is the my lord order passed by the appellate authority. My lord, basic question your lordship kindly see. But while reversing the judgment, first, my lord, you have to, my lord, formulate the point of decision, point of determination. That is the basic, my lord, of the my lord order 41 rule.
Yes, point for determination. Yes.
Point for determination. But here, my lord, your lordship kindly see. Although, my lord, there is discussed, my lord, there is no point of determination was formulated, my lord.
Okay.
Man, appeal was, my lord, reverse, my lord. Your lordship kindly see, I will come to that, my lord. But before that, my lord, they have issue, my lord. Issue-wise discussion was that, my lord. Main issue was that there is a barred by section 154 of the Land and Regulation. But that is no longer a, my lord, good law right now, my lord. There are a lot of decision, my lord. In fact, my lord, one very latest decision of the apex court, my lord. My lord, I'll place this 3 decision before your lordship, my lord.
AL double R, no? Short form,
My lord.
AL double R. Assam.
And Assam Land and Revenue Regulation 1918.
AL double R, no?
AL
Short
double R.
form.
2002 1 GLT.
2002 1 GLT.
1 GLT, page 176, para 4, my lord.
Party name.
Party name, my lord, Urmila Bala Devi, 2002, 1 GLT, 176. In this Justice Jain Somaj judgment, my lord, in very clearly, my lord, in para 4, my lord, that is described. Para 4, my lord.
Yes.
That is, my lord, party's name, Urmila Bala Das versus Bhubaneswar Das. That is para 4, my lord. Then another judgment, that is 1989, 1 GLT, page 37. That is a division bench judgment of our High Court. That was a special bench, my lord. Sorry, my lord, it's a full bench. The full bench judgment, 1989, 1 GLJ, page 37. Page 37.
1989 1 GLJ.
GLJ, page 37. Dolotam Lakhani versus State of Assam and others.
All right.
Clearly mentioned that, my lord, in para 22. Para 22, my lord. Para 22, my lord, I'll just. If pair 22, when complicated question of relating to the title are involved, my lord, that the 164 is 154 is no bar. That there is a finding, there's a reference made to that, there's a full bench, my lord, probably that will answer. And considering all these things, there is a Supreme Court judgment that is in 2020, the very recent, my lord. That I will give a judgment, my lord. It was decided on 2012-2024. Appellant Abdul Razak Laskar, it was very one eye. In para 55, my lord, last para, my lord, everything is, my lord, all discussing. This is a case from Assam, my lord, that there is no bar. So, my lord, your lordship kindly see, I'll come and next substantial question of law, my lord, I'll come to that, my lord. Because that was not at all considered by the lower appellate court, my lord, the first appellate court, my lord. In fact, my lord, there's a finding also, my lord, that is in my favor by the appellate court. It is true that the section 154 of the aforesaid regulation does not debar the civil court from entertaining a suit based on title.
Yes, yes.
But my case is based on title, my lord. My God, your lordship kindly see what happened, my lord. This actually, I purchased the land from Phaguni, but my father purchased the land from Phaguni. and best respondent purchased the land from my lord Sadori. Sadori and my lord, not Sadori, my lord, from one Noran who purchased the land from Sadori, my lord. So they are unpartitioned land, my lord. That's why I instituted, Phaguni instituted title civil suit, my lord, in 1964, my lord. That judgment was called for, that is before with the record, my lord.
This is para 55.
My lord, oh yes, my lord, then the recent judgment I have made. I think so. May I read? I'll read it. Yes, the lordship, my lord, for. Fifty-five is that is my lord. 56, my lord. Further, the decision rendered by the daughter of Lakhani versus State of Assam and correspondent number so and so, the operated in so and so and Guwahati Lakhani so and so. The High Court of Guwahati itself has clarified that the bar created by the section 154(1) does not preclude the suit based on the title on the property from being within the jurisdiction of the civil court. Detailed discussion in my lord, all the para that mainly para 55, my lord.
Okay, 55 and 56.
My lord. Because although there is no, my lord, if your lordship go by the appellate court judgment, my lord, there is no point for determination was formulated. Even assuming that they have formulated a point, the point what they have, slightly one line is there, that whether it is barred by 154 or not. That is the only, my lord, issue to discuss. That is there is a line I have seen, my lord, on para. But in the appeal, my lord, your lordship kindly see, in the appeal preferred by the learned before the first appellate court, I have seen the memo. In the memo, my lord, their only question is that they have taken, my lord, that there is barred by this, no civil suit is barred, civil suit is barred. So, my lord, there is an ample example. There is not a single judgment placed before the court, either by the trial court or before the, my lord, appellate court, my lord. These are the judgment prior to that. Probably one or no, that is after that, my lord. And regarding, my lord, point of determination, my lord, I would like to place, my lord, two judgment before your lordship.
It is there in the court.
My lord.
Point of determination has to be framed. It is there in the court.
My lord.
In the
Yes,
court.
they are in the code also. Yes, but that is, my lord, they are supported by some of the judgment I would like to place, my lord. Because that is the appellate court has the only duty, my lord. That is the duty that just to first they have to formulate the point of determination. In that, my lord, regard so many cases, my lord, referred back by the High Court to the again, but they demanded back to the lower appellate court, my lord. Your lordship kindly see 2022 3 SCC, my lord. 2022 3 SCC. Page 90, my lord.
Yes.
Page 90. 2022 3 SCC. Page 90, my lord. Para 8, my lord. The small judge, very small judgment. The section 96 of the Civil Procedure Code 1908 for the first that provided that the filing of an appeal for the decree passed by the court of original jurisdiction, the order 41 rule 31 CPC provided the guidelines to appellate court for deciding the appeal that does mandate that the judgment of the appellate court shall state point of determination, my lord. So another judgment, my lord. 2021 10 SCC, Triple 7. No, I will give a synopsis, my lord. If
Okay.
I will give a synopsis of details, my lord. I will mentioning that if required, I will give a judgment note. one photocopy of the judgment is to your lordship. Hasn't it? So she will go to I'll mention the para also, my lord. And there is another two judgment of our GLT also. I will place this for my lord. So my submission before your lordship kindly see. I purchased a plot of land from a recorded potter. There is no dispute that, my lord. I based on that, my lord, I claim my title. Apart from, yes, the court may not grant, my lord, order for mutation, cancellation of the mutation, my lord. That can be, but my lord, your lordship can, that's why, my lord, I formulated a substantial question of law. The whether lower appellate court committed an error by denying the declaratory relief to the suit for the right title and interest. At least right title and interest, because my sale deed was not been challenged by anyone. I claim my title on the basis of the sale deed, which was, my lord, yes, it was given by Phaguni. Phaguni has sold his land, her share of land, my lord. Because earlier suit, my lord, which was instituted by Phaguni, well, that was, my lord, joint, my lord, possession was declared by the suit. That judgment still exists, my lord. So that judgment still exists. There is a finding of the lower appellate court also. So since that is exists, then, my lord, still alive. So she is still alive. So my right title interest, apart from, my lord, cancellation of mutation, apart from question of that part, my lord, limitation will come, my lord. But here in that part, my lord, and when I call for, I paid for a title, my lord, that cannot be, my lord, because of the land and regulation 154, man, that cannot be a bar, my lord. So that's why, my lord, substitution question of law 3 also, my lord, one of the very important, my lord. Apart from 19, that is regarding, my lord, whether the learned lower appellate court misconstrued the provision of law laid down in an aspect of section 154 of the Assam Land and Revenue. So my submission before your lordship, these, my lord, two question, my lord, at least, even, my lord, without going to that formulating, my lord, that point of determination, my lord. And that is also one of the ground I have taken. But I'm stressing on these two ground, my lord. Assuming, my lord, that declaratory suit, my lord, that title has to be has had, because already, my lord, one portion of the land still, my lord, lying vacant. And he taking the advantage of, because it is adjacent to their land. It is adjacent to their land, my lord. It's a clash between two sisters, because I am purchased, my father purchased from one sister, and they also purchased from another sister. But another, that she has sold, entire land was sold, my lord. So I am claiming on the share of the, my lord, the Phaguni, my lord, which was sold to Mona and Mona sold to me, my lord. So my submission before, lord, there is a substantial question of law. This question 2 and 3, my lord, that has to be, my lord, fulfilled. So, my lord, for the, if your lordship go by the point of determination, then, my lord, it can be remanded back to the trial court, land lower appellate court will decide the issue, my lord. So that is my submission, my lord.
My pleasure, Lordship. Lordship, this, for admitting this appeal, your Lordship framed two issues, substantial question of law. Basically, section Article 154 of Assam Land and Revenue Regulation. Very well. Article 154 Land and Revenue Regulation exempted cognizance to take cognizance by civil court, Lordship, on certain matters that has been described specifically from A to M of that particular article regulation 154. And secondly, Lordship, in first substantial question of law, another aspect is there, that is section article 65 of the Limitation Act. Lordship knows very well, limitation is a mixed question of law and facts. Whether that particular article 65 will applicable or not, that to be decided on the basis of statement made in planned, Lordship. So it is section 54 of Assam Land and Revenue Regulation is also based on the statement whether that particular article will attract or not. That will depend on the planned, Lordship. Here, for deciding first point, substantial question of law, the plant is very much necessary. Just basically the claim of the plaintiff side. But it is very unfortunate. respected counsel for the appellant side did not read the plan of the original suit, Lordship. And second substantial question of law, that is, Lordship, based on misconstruation of judgment and decree dated 23/7/1969 passed in learned trial court and disregard of materials on record. For that also, Lordship, the planned written statement as well as evidence of the both parties is very much necessary. Unfortunately, that has not been shown before your Lordship.
That whole judgment was discussed.
No, Lordship.
Both the judgments
Here,
have been-
before coming to planned, Lordship, kindly,
The copy of the plaint is annexed with this.
Annex, my lord, I have annex, my lord.
Page
that
number-
is what I will see, Lordship. The
Plain and WS annex, my
The
lord.
plaintiff has no case at all, and the plaintiff side presented a very, Lordship, if your Lordship kindly peruse the decision of learned First Appellate Court in last part, page number 31. Kindly peruse page number
Please
31.
read it, no?
Yes,
Entire
it
judgment
is specifically held the entire plant is a celebration of readiless place before court of law, waste practice of judicial time, and the respondent failed to come with clean hand. That I will show from the plant itself. Kindly peruse plant first, Lordship.
Page 31.
Page 35, Lordship.
How much time will you take?
I will show materials, Lordship, which has not been shown by respected counsel for the appellant
No, I
side.
am on the
Then
law
the
point, my lord.
arguments will be left over, I think. It's already 3 other matters will be left over, or you will wait. You'll prefer to
What's that?
wait. He will take some time, I'm sure. From 2, he has continued till 3. And I'm sure he will continue from 3
Yeah,
to
Lordship.
4.
Next day,
Huh? Left over. If you want to wait, you can wait. Take a chance.
My lord, item 18, my lord, a date may be fixed.
Item 18. It will लिखी कोई नहीं date का fix कर दे.
Other party is enjoying.
Date का fix कर देगा. Short data का ही दूँगा.
No, my lord, there is urgency, my lord. He is not paying maintenance, my lord.
I am for a petition, maintenance they are getting. Within month, I have no space, in the hearing here. So, after 6 June or 10 June.
Last, Dada, last.
Last, no, that much. 29, I have 4 hearings.
27.
Last set of hearings.
Lord, they are enjoying, my lord, stay, my lord, that is why, my lord. Every time we will get it listed by mentioning 344, my lord, that is part 27, my lord.
I think he's busy. That's what.
29 he is big.
Keep them, my lord, if the sufficient.
Keep June.
Lord.
बाकी वो लैपटॉप को करी. Yes.
Page 35, Lordship. We will find plan. The original suit was filed by Dharmeshwar Bara. Kindly, one important point, Lordship. Dharmeshwar Bara is son of
Yes.
Sadori
I
Sutia.
have noticed it.
And Sadori Sutia and Phaguni Sutia are were sister, Lordship. They are sister in relation. Sadori Sutia and Phaguni Sutia.
Yes.
Then, Lordship, kindly peruse, Sadori Sutia and Phaguni Sutia jointly own, Lordship will find at page number, paragraph 3, page number 36, land measuring 2 bigha, 4 kotha, 5 lasses. Paragraph 3, Lordship. On statement of the plaintiff side. 5th line. 2 bigha, 4 kotha, 5 lasses.
Page, para number?
Paragraph 3, Lordship. Internal page 2 of the plant.
Okay, yes. There are 3 years. Okay.
May I please, Lordship? Our item, Lordship, item number 15, date has not been fixed, Lordship. Both the parties are here, Lordship, on 12th June.
So Lordship, it is admitted possession. The predecessor of the Faguni and Sodori owned 2 bigha, 4 kotha,
Yes,
2.5 lasa. That is, both the sister are entitled 1 bigha, 2 kotha and half lasas.
Yes, yes.
Now, kindly peruse what is the claim of the plaintiff.
So
If
this,
your
the Faguni Sutia is the mother of Dharmeshwar, no?
mother of
No, no,
yes,
no, no.
Dharmeshwar,
No.
Dharmeshwar Bora Soikia.
Mona, Mona.
I will show from cross examination of Dharmeshwar Soikia, Lordship. I will
Faguni's
show.
mother of Mona, no?
Yes.
Mona.
No,
Mona
Lordship,
Sutia.
as per admission made in PW1,
It has been mentioned in the judgment, somebody.
Yes, my lord, there
It has
is
been mentioned.
no,
mentioned, that's
in
why I'm-
cross examination, that PW1 himself admitted Sadari Sutia is his mother. I will show from the record itself.
Oh, Sadori Sutia, no?
Sadori Saikia or Sadari Sutia.
Yes.
Earlier, he was known as Sutia, and after marriage with Mona Soikia, that is father of the plaintiff, she used to write.
It is mentioned in the appeal.
Yes. Then,
Judgment in the judgment.
then kindly peruse Lordship. Here in paragraph 1 of the plaintiff claim ownership 1 bigha, 2 kotha, half lasas. And in first line, plaintiff and pro forma defendant number 11 to 14. I think it ought to have been 11 to 14. So here, the plaintiff is not the only legal heir of Mona Soikia. It is admitted possession from the plaintiff side that plaintiff and pro forma defendant number 11 to 14 are legal heir of Mona Soikia. Here, suit is based on inheritance right, as per own statement. But unfortunately, Lordship will nowhere find in the plan, in remaining part of the plan, how the plaintiff became exclusive owner of the suit land. In one hand, the plaintiff claiming inheritance right, and on the other hand, the plaintiff himself stated, the plaintiff and pro forma along with her sisters, pro forma defendant number 11 to 14. Then, kindly peruse one part, how the father of the plaintiff became owner of the suit land. That is Schedule A. 1 bigha, 2 katha, and 2.5 lasa. Lordship will find in paragraph 2 of the plan, by virtue of shall deed 4235, dated 25/8/1971. That part is vital, Lordship. The father of the plaintiff became owner. White shall deed executed on 25/8/1971. And here in paragraph 3 of the plan, the plaintiff himself stated about title suit number 64 of 1962. Who was the defendant of that suit? Kindly, that point may be noted, Lordship.
Yes, yes.
Who was the defendant in title suit number 64 of 1962 as per own statement? Here against, prior to execution of sale deed so and so, in Faguni Sutia instituted title suit number 64 of 1962 before the court of Munsif Jorhat against Niren Saikia. That is my immediate vendor, who was impleaded as defendant number 1. Then Sadari Saikia, the mother of the plaintiff. Mother of the plaintiff was also party as defendant number 2. Sadari Sutia allies Sadari Saikia. And third defendant, Lordship, is Mona Soikia. That is father of the plaintiff. And fourth, Your Honor, Lomthai Kalita. Before coming to other part, Lordship, kindly another point may be noted, Lordship. The chain of title of the defendant side. That part is vital. Lordship, that Sadari Sutia allies Sadari Saikia on 11/1/1951, sold to Lomthai Kalita, the mother of the plaintiff. In the year 1951, sold to Lomthai Kalita. Then that Lomthai Kalita on 4/5/1956, after 4 years, executed and again sold to Niren Saikia, that is defendant number 1 of earlier suit. Then that Niren Saikia on 6/1/1961 sold to George Beck, that is present respondents. Here, it is admitted position, Lordship, from the own statement of the plaintiff side also. I will so cross-examination. George Beck, original title of George Beck came from the mother of the plaintiff, that is Sadori Sutia. The chain of title, the first owner of the defendant cell deed, Lordship, George Beck cell deed, Sadori to Lomthai, Lomthai to Niren, then Niren to George Beck. That is why, yeah, Lordship, here, if your Lordship come to other part of the plan, I will show some effective statement whereby the plaintiff side claim challenge the ownership of defendant, that George Beck. Lordship, defendant side got title from mother of the plaintiff through Niren Saikia. Now, the same plaintiff claim title of that George Beck, challenging that title, or that is that cell deed. Lordship, that is why the legislature, Your Honor, brought estoppel, law of estoppel. What is law of estoppel? If my predecessor did something, I am binding on it. If the title of the George Beck came from the mother of the plaintiff, that plaintiff is binding, Lordship. As per law of estoppel, plaintiff cannot challenge until and unless taking any ground of fraud and the sale deed of that of his mother. Secondly, Lordship, if your Lordship kindly peruse Exhibit 2. Exhibit 2. Lordship will find the judgment of title suit number 62 of 1962. One flag will be there, Lordship, with Elsier. I'll reply paragraph wise. It will be effective, Lordship. C file, that will be with C file.
Wait. Yeah.
Yes.
Yes.
Judgment of title suit number 1964 of 1962. Kindly peruse effective part. Effective part, Lordship. That order portion. That was flagging, Lordship, while I got for
Judgment
that.
of title suit.
1964 of 62. That is
One that this is not relevant here.
That is relevant, Lordship. That I will show. Because the statement made by the plaintiff in paragraph 3. And this is their basis, Lordship. The plaintiff filed the suit on the basis of that judgment.
But I'm not getting the judgment. Yes, Swapna sir, judgment of 64 of 19.
One pink color flag is there. Just I tagged before 2-3 hours.
Flag আছে কিন্তু নাই এর ক্রস আছে exhibit 1
exhibit 2 exhibit 1 or পিছতে
exhibit 2 আছে নহয় এটা নহয়
exhibit 1 বুলি এখন লেখা আছে আছে ক্রস তার পিছতে আছে immediately after exhibit
judgment নাই ও এটা আছে
last part effective portion
here okay No, no, it will not. It will not. Yes, yes.
Last part, Lordship. Does suit be decreed on contest? Lordship, got it. Last page.
Yes, yes.
The suit be decreed on contest which cast against defendant number 1 and defendant number 41244 and expertise without cost against defendant number 2 and 3. The plaintiff right title interest over half share of suit land is hereby declared. Next portion, Lordship. She will be in joint possession of the same along with defendant number 1, 2 and 3. Now, who is the defendant number 1, 2 and 3? Defendant number 1 is my vendor who executed my sale deed in the year 1961. Defendant number 2 is the mother of the plaintiff who was initially sold out the suit land in the year 1951. In the year 1951, the plaintiff, defendant number 2 of that suit sold out the suit land to defendant number 4 of the same suit.
It's mentioned, no? It's mentioned.
That is why. And who is defendant number 3? That is father of the plaintiff. Lordship, the main basis of the plaintiff side judgment of this suit. By that judgment, the learned trial court specifically directed to be in possession
Yes, yes.
with me. Because Niren Soikia was my vendor. Now the same plaintiff on what basis can seek ejectment from the same property, Lordship? By that judgment, the plaintiff is duty bound to be in joint possession with me. Now the same plaintiff, Phaguni Sutia was directed to be in possession with me. Now, on the basis of this judgment, the plaintiff sought decree of ejectment of Niren Saikia, who was my vendor, and the present respondent, who sold out to me in the year 1961. And that judgment was passed on, Lordship, on 23/7/1969. That is after 8 years from the date of my sale deed, Lordship, which was executed in the year 1961. 6/2/1961, and this judgment was passed on 23/7/1969. And as held by First Appellate Court, Lordship, that judgment attained finality, and in the year the suit filed in the year 99 cannot override on that judgment, Lordship.
Yes.
Here, the learned First Appellate Court rightly held then how the plaintiff misrepresented the court waste time, Lordship. Here, plaintiff projected case as if Phaguni Sorodi Soikia, that is his own mother, sold out entire land. That means all land. If Phaguni Sutia, Sodori Sukia, mother of the plaintiff, sold and
Sarodi is not mother of the plaintiff.
I will show from the
Sarodi
record,
is not
Lordship.
mother of the plaintiff. Phaguni.
I will show from the record itself, Lordship. That is correct, Lordship. Lordship, as per statement made in paragraph 3, mother of the Sodori and Phaguni own 2 bigha 4 kotha 5 lesa. If it is divided into 2 part, Lordship, it will 1 bigha
4 kathas. It's
2
okay.
katha.
Nicely divided by the
Yes.
judgment.
Now, here that Sodori was sold out to Lamthai, 1 bigha 3 katha, only 13 lesa. Only there is a gap of some lesas of land, Lordship. That Sodori Sutia did not sell entire land. It may be 55%, leaving behind other 45%. That clear statement is not in the plan, Lordship. Next, Lordship. I will place judgment, Lordship. I have also prepared a written answer. Here, the law of Estoppel and other part, all decisions are specifically highlighted. Now, before coming to other part of the plan, Lordship, kindly peruse prayer portion. Lordship will find at page number 41 the prayer portion. The first prayer, pass a decree of declaration of right title interest of the plaintiff over the suit land. Now kindly, Lordship, I want to refer section 34. For filing a suit for declaration of right title interest, plaintiff must fulfill the ingredient of section 34. Someone must deny title. Without denying title, no suit for declaration of right title interest can be filed, as per section 34 of the Specific Relief Act. I want to read
Yes.
section 34, Lordship. Then Lordship will consider whether there is any statement regarding denial of title by the plaintiff side, by the defendant side. Declaratory decree. Discretion of the court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interesting to deny his title. So without denial, without any statement of denial, no suit for declaration of right title interest can be filed. That is the basic requirement for any declaratory suit under section 34 of the Specific Relief Act.
There's a second line also, denying or interest to deny.
Yes. The title must be under apprehension, Lordship. So without apprehension of title, no degree of declaration can seek, Lordship. Then kindly peruse, Lordship, to save time, Lordship, I want to rely Article 64 and 65 of the Limitation Act.
There's a limitation act too.
What 64 and 65 says.
ইয়ার আছে নি তাতে আছে এখনো Okay.
Also effective part, whether the suit based on title or possession. Before coming to effective part of the plan, kindly peruse Article 64 and 65.
Okay.
Here,
There has to be dispossession.
for possession of immovable property based on previous possession, not on title, when the plaintiff, while in possession of the suit property, has been dispossessed 12 years from the date of dispossession. If suit is filed only on the basis of possession without title, then kindly peruse 65. For possession of immovable property or any interest thereon based on title, that is also from 12 years. But here, when the possession of the defendant become adverse to the plaintiff. If possession of the defendant side is adverse, then 12 years from the date of possession of the defendant side. Now kindly peruse plan, Lordship. Paragraph 7, page 38.
Paragraph 7, okay.
Paragraph 7, page 38, internal page 4, Lordship. May I read, Lordship?
Yes.
Mona Soikia, the father of the plaintiff, after purchasing the suit land from Phaguni Sutia took over possession of his purchased land measuring 1 bigha, 2 kotha, 2.5 lesa under Dag number 696 and 698. But after date of Mona Soikia, portion of said land measuring 4 kotha, 6.5 lesa under Dag number 698, PP number so and so, was illegally occupied by the defendant on or about 15/10/1980 and constructed a pakka building by the father of the defendant, taking advantage of absence of the plaintiff. Description of remaining land measuring 4 kotha 6.5 lesses are specifically mentioned in Schedule B and shall be referred suit land. Here, Lordship, kindly peruse when suit was filed. So admittedly, suit was filed in the year 1999, which was subsequently renumbered in the year 2006. So suit of 1999.
And dispossessed on.
Dispossessed as per own statement. 15/10/1980. That is, suit was filed after 19 years. And as per 65, even if assume the suit of the plaintiff is based on title, then also plaintiff ought to have been preferred the suit before 1992. And that suit is filed, Lordship, in the year 1999. Now here the plaintiff side specifically stated one contradictory statement is there. I want to show that part also, Lordship. Illegally occupied by the defendant on or about so and so. It's same paragraph, just I want to repeat it, Lordship. To show contradictory statement from own plant. Constructed a pakka building by the father of the defendant, taking advantage of the plaintiff. Here, as per statement of the plaintiff, defendant not only dispossessed but also constructed a pakka house, as per their own statement. Now kindly peruse paragraph 9. Paragraph 9. Next page, Lordship. Married, Lordship.
Yes.
The defendant taking advantage of aforesaid illegal sale deed, that is sale deed of 61, forcibly occupied the suit land shown in the schedule below, when that time is not mentioned. From portion of the land is remain vacant, and remaining area there are some bamboo and mango tree and old pond which are existed since the days original Pattadar Consutia. Now version is something different, Lordship. Here said on particular date of 1980, dispossessed and constructed a pakka house. Here it is averred, Lordship. Front part is vacant, remaining part mango tree, old pond, since the date of Consutia. Now kindly peruse, Lordship. Now I will show what the plaintiff side admitted in cross-examination. Now my humble and respectful submission, Lordship, even if assume the suit is based on possession, then also 12 years from the date of disposition. And if Lordship consider no, suit is based on both title and possession, then also it ought to have been filed within 12 years. From Article 64 and 65, both. Here, date of disposition was mentioned by plaintiff himself. So, from the own statement, suit is barred by limitation, Lordship. And that is rightly held by the learned First Appellate Court. Although section was referred in 65 only, from both angles, 64 and 65, suit is barred by limitation. Now, Lordship, here the basic question, Lordship, will come in another way. So suit is estoppel is there. I have already submitted before your lordship. The another part will come, lordship. Even if assume that decree passed in 1962 is valid, then lordship, in entire plan, lordship will not find any statement whether after passing that judgment in the in 1962 suit, lordship, and it is also first it is not mentioned whether that decree was executed or not, whether the plaintiff actually plaintiff of that suit, that is vendor of the appellant side versioner, came into possession or not. That is to that part, lordship, plaintiff is totally silent. Secondly, lordship, this part is also silent that even if assume for a moment we assume that the plaintiff, that Phaguni Sutia got his possession, the plaintiff is also silent whether the land between Phaguni Sutia and other possessor were partitioned or not. There must be, lordship, post-partition after judgment of 1962 suit. So no statement is there. Because plaintiff is claiming a definite share on the basis of title of Phaguni Sutia. That execution of that judgment must be there as well as partition. So without execution and partition, how Phaguni Sutia became owner of the land as described in Schedule A? That is not there, lordship. Now, lordship, I am on now first substantial question of law. Jurisdictional bar under regulation 154 of Assam Land and Revenue Regulation. Now, kindly some part of the plan, lordship, because it is settled proposition, plan will determine the category of the suit, not as per the statement made in written statement.
1886, no?
Lordship.
Okay.
Now, kindly peruse the statement made in paragraph 6 of the plan, lordship. On another submission I made, lordship, there is no statement regarding denial of title from respondent side as per requirement of section 34. That will also, lordship, can be considered while decide for substantial question of law. Because maintainability issue is there as a whole. In that part also
Yes, yes,
can
I
be
have
considered.
noted it.
Kindly peruse paragraph 6, lordship.
Yes, yes.
What is the suit for actually? May I read, lordship? Paragraph 6, page 38, internal page 4. That on the strength of said illegal transfer deed, George Beck mutated his name as per order of Sitha mutation, and separate patta 627 is made illegally as per order passed in Sitha dated 18-10-1965 by concerned SDC, Proforma defendant number 15. Said mutation order was passed illegally without observing required procedure as per provision of Assam Land and Revenue Regulation. No notice also served to the other co-pattadar at the time of passing the order of mutation and partition, and as such the order of Sitha mutation and order of partition dated 18-10-1965 is liable to be declared as illegal and inoperative in law. Learned SDC had no jurisdiction to pass order of partition. Now, whether here in view of that statement, the plaintiff also made specific prayer. Lordship will find prayer number 3 at page 41, internal page 7. Prayer number 3. Pass a decree declaring the mutation and partition order passed by SDC Jorhat East Circle is illegal and not operative in law. That order was sought, that decree is sought in form of declaratory. If Lordship kindly peruse the prayer portion, pass a decree declaring the nature is declaratory. As per that will attract 34. Lordship kindly peruse 154 E. As because statement is there regarding issuance of separate patta along with mutation. 154 E says, Lordship, claim of personal imperfect partition.
Yeah, ARR, no?
Yes, Lord. Regulation 154 E.
Yes, 154E, yes.
Claim of person to imperfect partition except in cases in which a perfect partition could be claimed from and been refused by revenue authorities, and on that ground the result of such partition would be from a separate state liable an annual amount of revenue less than 5 rupees. So it may be perfect, it might be imperfect. Revenue must be below 5. In that case, Lordship, aggrieved party must follow the jurisdiction as laid down under Assam Land and Revenue Regulation. Now kindly peruse, Lordship, Exhibit 3 filed by the plaintiff side. Lordship will find immediately after Exhibit B, that judgment, Lordship will find Exhibit 3. This is their document, Lordship.
Exhibit 3, no?
Exhibit 3. A patta, a big patta,
Yes,
Lordship.
yes.
Kindly peruse note number, first note, Lordship. First note, Jamabandi.
Yes, please read.
চিঠাৰ উপসমাহৰ প্ৰতি সমাহৰ্তাৰ 18-10-65 টাং হুকুম মতে 698 ডাগৰ তাৰিখ ডাগৰ 1 বিঘা 3 কঠা 13 লেচা জমিত নীৰেণ চন্দ্ৰ শইকীয়াৰ স্থলত হৰিদা সূত্ৰে জৰ্জ বেগৰ নাম হৈ 2 টকা 13 পইচা. Revenue must be below 5, Lordship. I have already read that provision. Khazana hoho ei pattar pora prithok hoi 627 patta loi jai. Here 2 points are there. 1 point limitation, other point is 154 regulation. Regulation 154 will directly attract, and that document was submitted by plaintiff side. This is not my document, Lordship. I have yet to rely written statement and my cross and other document. This is the document of plaintiff side. So this order was passed on 18/10/1965. Now kindly peruse when that Exhibit 3 was issued. Date of issuance, Lordship will find in below authority. 15/6/1983. So plaintiff came to know about that revenue rectification, revenue correction on 15/6/1983. This is their document, Lordship. A suit was filed in the year 1999, after 16 years from that document. If Lordship, as per statement made in paragraph 6, as well as the prayer made white prayer number 3, the plaintiff is aggrieved because of this revenue correction. This particular revenue correction, they ought to have been preferred Lordship revenue appeal before the concerned authority as per jurisdiction laid down under Regulation 147 within 60 days from the date of knowledge.
Yeah.
And apparent Lordship, this Zababandi Exhibit 3 will attract 64 and 65, Lordship. 16 years before. Now, kindly peruse, Lordship, as because the learned First Appellate Court held that the suit of the plaintiff is not based on title, it is based on possession. Why it is held? Lordship, if come to the entire plan, as because Lordship knows one principle, pleading has to read as a whole, not in a part. In entire plan, Lordship, there is no whisper regarding denial of title. Here, the plaintiff categorically stated in the plaint, as well also in cross-examination, I am going to read cross-examination of PW1, that their suit is specifically on the basis of their earlier possession. I will not read entire plan, Lordship, to save valuable time of your Lordship. Here, the basic claim, their mother and sister of mother, owner of entire land.
Yes.
Then his possession continue since the date of 1971. Since the date of 1971, when Phagune Sutia executed sale deed in favor of his father, 1971. Here, suit is basically based on possession, Lordship. Since they failed to make any statement regarding denial of title. Here, suit is based on disposition. On particular date, I have been dispossessed. Since I have title on the basis of this deed, I need recovery of possession. And the sale deed of the plaintiff, defendant side, the predecessor of the defendant is illegal. Again, I want to remember one another thing, Lordship. My source of title is based on the title of the plaintiff predecessor that I have already submitted before your Lordship. Now, Lordship, as per principle of Lordship estoppel, plaintiff cannot question, as because my title is based on his predecessor. He is debarred. And Your Honor, some contradictory other statement is there. Just I want to submit it within a minute, Lordship. In paragraph 1, if your Lordship kindly peruse, they have stated about DAG number 696, 695. But in the schedule, Lordship, they have mentioned one DAG number 695. That contradiction is there. In next paragraph number 3, Lordship, they have stated about DAG number 696, but 698 is not there.
In schedule of the plain.
Yes.
But in first paragraph.
In every statement, Lordship, in various statements are there, they are self-contradictory. In paragraph 1, they stated about DAG number 696 and 698, but in the schedule, they stated about 695 and 698. In schedule, Lordship, 696 is not there. Similarly, in paragraph 3, Lordship, DAG number 698 is there, 696 is there in line 7, Lordship, if I am not mistaken, but there is no mention of DAG number 698.
Okay, okay.
And here, another Lordship will find their main target. Their main target is to possess entire land. One by way of inheritance from Sadari Kalita. That statement is there. I am going to show from paragraph 8. And another by way of purchase. Their main target is to possess entire 2 bigha 4 kota 5 lasa. Their main target is. That is apparent from the statement made in paragraph 8. Lordship, kindly peruse paragraph 8 of the planned Lordship. That will itself crystallize their malified intention. May I read, Lordship? The land measuring 1 bigha 12 lasses under DAG number 696 was inherited by the mother of the plaintiff, Srimati Sarodi Sutia. It is admitted, Sarodi Sutia is mother of the plaintiff. That is why I am repeatedly submitting, Lordship. 1 bigha 12 lassa under DAG number 696 was inherited by the mother of the plaintiff, Sarodi Sutia and Phagune Sutia. Lordship, if Sarodi Sutia in the year 1951 sell out the suit land to respondent defendant number 4 of that suit, Lordship, how the plaintiff can claim inheritance right in the year 1999. Then, Lordship, thereafter the plaintiff's father Mona Soikia inherited the suit land and and the name of Mona Soikia was mutated as per order dated so and so, so and so. So after death of Sadori Sutia, the name of Mona Soikia was mutated as per their own statement. Whereas that Sadori Soikia gave away her title in the year 1951 itself. So their main intention is to possess entire land. Now kindly peruse Lordship, pros of PW1. Flag mark is there, Lordship, in C file.
Cross-examination.
Cross-examination of PW1.
Yes. Cross of PW1, yes.
Because issue number, substantial question of 2 number is there, non-consideration of materials. Here the statement of plaintiff side, the plaintiff side will support my entire earlier submission. Mukabila Vivadi, Senimai Bora, Mur Baideu. Aru Oni Soikia, Mur Bo Hoy. Sarigao Mojar, Maud Gaor, Deutai Eho Unohati Nong Patter, Soho Posanoboy. Here 696 is not there, 695. Aru 698 Dagor, Dui Biga, Dui Kotha, 2 and Arhoi Lesa, Mati, Faguni Sutiar Pora registered Dolil Zuge Loisil. 25/8/71 তাৰিখে কিনিছিল ফাগুনি চুটিয়াই টাইটেল সুট 64-62 গোচৰত যোৰহাট মুন্সিফ আদালতত নিৰেন শইকীয়া আৰু কেবাজনৰ বিৰুদ্ধে ডিগ্ৰী পাইছিল মোৰ মা হাদৰি আৰু উক্ত ফাগুনি বাই ভনী again supported the Faguni Sutia or Elias Faguni Soikia is mother of the plaintiff. Title suit 64-62 Fagunie Pua Matie Faguni Pua Matie E Gusoror Bibadio Mati. Now what they have stated? Fagunie Pua Matie E Gusoror Mati. That is why I have referred paragraph 8, Lordship. In one hand, they sought an land purchase white shell deed, and on the other hand, they again want to possess by way of inheritance. Fagunie Ukto Dikri Pua Mati Fagunie Mur Deuta Mona Bora Bikri Kore. Faguni Aru Hadori Gosoria Hompurno Pattar Matit Malik Asil. Matitu Teolok Kon Sutiar Pora Paisil. Kon Sutia Amar Aita. Teor Lora Nasil. Fagunie Niren Teor Onghor Matikhini Pua Buli Dabi Korisil. Karone কেছ কৰিছিল কেছত জিকাৰ পিছত ফাগুনিয়ে আমাৰ দেউতাক মাটি বিক্ৰী কৰাৰ পিছত নিৰেন শইকীয়াও সেই মাটিটোকে জৰ্জ বেগক বিক্ৰী কৰে and that is admission of sale deed of 1961 নিৰণৰ আন এটা নাম নলিয়া ফাগুনিয়ে নিৰেনক কেতিয়াও তেওঁৰ অংশ বিক্ৰী কৰা নাছিল ফাগুনিয়ে Nirenok, তেওঁৰ অংশ কেতিয়াও বিক্ৰী কৰা নাছিল Yes, Lordship. Faguni was sold to Lumthai Kolita. Lumthai Kolita sold to Lordship. Yes, Faguni did not sold his own land. That is why I did not challenge the sale deed of the plaintiff side. Because my sale deed is different, which was executed by mother of the plaintiff originally. And their land is totally different. Lordship already find in paragraph 8. And in remaining portion will say the land was sought for ejectment of the defendant is vacant in remaining part, Lordship. আদালতৰ হুকুম হোৱাৰ পিছত জৰ্জ বেগে গোচৰীয় মাটি চিঠাত নামজাৰি কৰাই ল'লে। This is false, Lordship. As per statement made in Exhibit 3, my name was mutated in the year 1965. And that decree was passed in the year 1969, after 4 years. That is wrong. নামজাৰি হওঁতে নোটিছ পাইছিল নে নাই মই নাজানো। দেউতাই উক্ত মাটি দখল লৈ এটা ঘৰ বনায়। Now statement is something different. দেউতাই উক্ত মাটি দখল লৈ এটা ঘৰ বনায়। কিন্তু 20-25 বছৰমান আগতে আমাক বেদখল কৰে জৰ্জ বেগে। জৰ্জ বেগে গোচৰীয় মাটিত নীৰেণ শইকীয়াই বনোৱা ঘৰটো দখল কৰে। Now this part is vital. জৰ্জ বেগে গোচৰীয় মাটিত নীৰেণ শইকীয়াই বনোৱা ঘৰটো দখল কৰে। Lordship, that Niren Soikia executed the seal deed in my favor in the year 1961. That's why George Beck got possession of that land constructed by Niren Soikia. But here in the plan, Lordship, there is no statement at all that Niren Soikia was disposed the plaintiff. Here statement is there, the George Beck disposes the plaintiff. Here statement is there, Lordship, George Beck গোচৰীয় মাটিত নীৰেণ শইকীয়াই বনোৱা ঘৰটো দখল কৰে। Exactly the house constructed by my vendor. এতিয়া সেই ঘৰটো কোনো নাথাকে। That house is vacant. গোচৰীয় মাটিৰ সীমাত থকা মাটিত জৰ্জ বেগৰ পুতেকে RCC বনাইছে। Now, as per own admission, the defendant is possessing in possessing over adjacent land, Lordship. এতিয়া সেই ঘৰটোত কোনো নাথাকে। গোচৰীয় মাটি সীমাত থকা মাটি মানে adjacent to the suit land. জৰ্জ বেগৰ পুতেকে RCC বনাইছে। সেই RCC ঘৰ বনোৱা মাটিটো গোচৰীয় মাটি নহয়। That is why I submitted, Lordship. The land under the possession of the defendant side is totally different, Lordship, where RCC structure is there. The land of the plaintiff claim is different. That ought to have been proved, Lordship, by calling revenue authorities. If you are not kindly peruse, I will show after reading of this effective portion, Lordship, the land as described in the cell deed of the plaintiff, Lordship, 4 boundaries are not mentioned. পট্টাত থকা মাৰ অংশ মাটিটো মাৰ মৃত্যুৰ পিছত দেউতাৰ নামে নামজাৰি হয়। Lordship, this part is vital, Lordship. That exactly supported the statement made in paragraph 8. পট্টাত থকা অংশত মাটিটোত মাৰ মৃত্যুৰ পিছত দেউতাৰ নামজাৰি হয়। That means, Lordship, after death of Sodori Sutia, alias Sodori Soikia, name of the father of the defendant is mutated by way of inheritance. That create main problem, Lordship. After that mutation in the year 1974, from their own record, Lordship, they started to assume that I became owner of both land, one by way of inheritance as wife or as legal heir of Sodori Sutia, and another part, Lordship, by way of sell deed. That is their main dispute, Lordship. Because name of Mona Soikia or name of plaintiff cannot mutate it over the land of Sodori Sutia. Because Sodori Sutia sold out in way back in the year 1951 itself, Lordship. গোচৰীয় 4 কথা 6.5 লেচা জমি মাটিটো আমি কোৱা, and that part is not legible, Lordship. অন্য গছ গছনি ইত্যাদি আছে। Now, Lordship, if your Lordship kindly for a moment peruse the statement made in paragraph 9 and 7. In paragraph 7, they have claimed that they have been disposed in the year 1980. In paragraph 9, they have stated that front part is vacant. In remaining part, land of mango tree and others are there.
Yes.
And the land under the possession of the defendant is lordship, they are possessing with RCC structure. So which is the suit land? That is why lordship, the first appellate court hold that the suit of the plaintiff actually wasting of time of valuable time of court lordship. They don't know which is the exact suit land. That is also not proved by calling revenue authorities. Their evidence of revenue authorities is not there lordship. Next and last part lordship. অবৈধভাৱে নামজাৰি কৰাই পাত্তা কৰি নিছে সেই মাটিটো এতিয়া খালি পৰি আছে according to own statement সেই মাটিটো এতিয়া খালি পৰি আছে উক্ত মাটিটো বিবাদী কোনো সত্ত্ব দখল নাই উক্ত বিবাদীয় মাটিত আমাৰ সত্ত্ব দখল ঘোষণা কৰিব লাগে আৰু পাত্তাখন অবৈধ বুলি ঘোষণা কৰিব লাগে বিবাদীয় মাটিত থকা ঘৰটো ভাঙি দিয়াৰ প্ৰাৰ্থনা কৰিছো এক্সিবিট প্ৰদৰ্শক 1 ফাগুনিয়া মোৰ দেউতা মনা শইকীয়াক মাটিটো বিক্ৰী কৰা ৰেজিষ্টাৰ্ড দলিল প্ৰদৰ্শক 2 6462 ৰ হুকুম আৰু ৰায়ৰ সত্য প্ৰতিলিপি প্ৰদৰ্শক জমা 3 জৱাবন্দী সত্য প্ৰতিলিপি that I have already shown both exhibit 2 and 3 I will show some effective part of exhibit 1 cell deed also then your honor গোচৰীয় খৰচ সহ ডিগ্ৰী পাব লাগে দেউতা ঢুকুৱা 18 বছৰমান হৈছে জৰ্জ বেগ ঢুকুৱাৰ কিমান দিন হৈছে মনত নাই গোচৰ লগা মাটিতে জৰ্জ বেগ ঢুকাইছে that is original respondent number 1 মাটিটো কনসুটিয়ালৈ তেওঁৰ this part is illegal সুটিয়াৰ পৰা পাইছিল ফাগুনিৰ 9টা লৰা আছে this part is also lordship Faguni has 9 sons. That part is also suppressed by the plaintiff side in their plan. 11/1/51 তাৰিখে পট্টাৰ সম্পূৰ্ণ মাটি লুমঠাই ওৰফে নিতাই কলিতা খদৰিয়ে বিক্ৰী কৰা কথা মই নাজানো 5/4/6/1956 তাৰিখে সামিয়ে সেই তাৰত মাটিটো নিৰেন শইকীয়াক বিক্ৰী কৰা কথা নাজানো গোচৰীয় আৰজি মই সহি কৰিছো গোচৰীয় আৰজিত উক্ত কথা লিখা আছে যদি মই নাজানো গোচৰত এসডিসি জোৰহাটৰ সাৰ্কুলক পক্ষভুক্ত কৰা হৈছে নে নাই নাজানো এসডিসি সেকশন 80 সিপিসিৰ নোটিস দিয়া হৈছিল নে নাই মই নাজানো জৰ্জ বেগে গোচৰীয় মাটি 6/2/1961 তাৰিখে নিৰেন শইকীয়াৰ পৰা কিনাৰ কথা মই নাজানো মোৰ আৰজিত 3 নং দফাত উল্লেখ কৰা 62/60 গোচৰৰ হুকুম বা ৰায় ডিক্ৰীৰ কোৱা কাগজ দাখিল কৰা নাই টিএছ 64/62 গোচৰত মোৰ দেউতাই এজন বিবাদী আছিলে that is defendant number 3 lordship 1 পৰা 7 নং বিবাদীক নামত গোচৰীয় মাটিটো পৃথক 627 জুৱা 18/10/1965 যদি হৈছিল মই নাজানো but his exhibit 3 says very clearly টাইটেল সুট 64/62 গোচৰত ডিক্ৰী দাৰি চলিছিল নে নাই মই নাজানো পিছত কয় কোনো ডিক্ৰী হোৱা নাছিল কোনো ডিক্ৰী দাৰি হোৱা নাছিল that means lordship after passing judgment in the year 1962's case lordship no execution was taken place that means Faguni did not came into the possession if in earlier that exhibit 2 suit lordship court declared joint possession of Faguni Sutia with his sister, so execution must be there within 12 years from the date of judgment lordship. The judgment was passed in the year 1969. So that ought to have been lordship filed on or before 1981. So that decree was also not executed. George Begor Gosoria Zamit Matitu, Patta Hote Ami Kuno revenue appeal Kora Nasilu. That means he, from the exhibit 3 itself, lordship, he knows about that revenue correction as well as issuance of patta in the year 1903 itself. That was not challenged. Appeal Kora Nasil, that is admitted. Moi Sakori Kori 33 বছৰ বাহিৰতে আছিলো. That is the real fact. He was outside for 33 years. That is why he don't know, lordship, what is the actual identity of the land, lordship. সত্য নহয় যে গোচৰ তামাদি হৈছে সত্য নহয় যে মই কোৰ্ট ফি ঠিকমতে দাখিল দিয়া নাই সত্য নহয় যে অন্যায় লাভৰ বাবে এই কেছ কৰিছো সত্য নহয় যে গোচৰ কৰাৰ অধিকাৰ নাই নাও কাইণ্ডলি পেৰুজ দ্য এক্সিবিট 1 cell deed lordship what is their land exhibit 1 more specifically schedule last part I want to read only their land whether the land described in schedule of the plant and the described in schedule exhibit A cell deed is similar. That is also under question. Schedule, by say lordship. Sorry.
I've got
Zila so and so, Sabrestri O Thana, so and so Moja, so and so Gaur. Purana Sarikho Sari Notun 159 number 303 Dagor. এক বিঘা এক কথা 12 লেচা বাৰী আধা ভাগ 2 কথা 16 লেচা পুৰণা 66 দাগৰ নতুন 698 দাগত 1 বিঘা 3 কথা 10 লেচাৰ আধা ভাগ 4 কথা 4 কথা 6.5 লেচা দুয়ো দাগৰ সৰ্বমুঠ 1 বিঘা 2 কথা 2.5 লেচা বিক্ৰী জমি metric পদ্ধতি মতে so and so where lordship kindly peruse here it is not specifically mentioned new dag 159 and 303 whether that land is connected with 696 695 or 698 and schedule 4 boundary is also not there so according to them only
just a moment, there's the Dag number 696. Sariko Sari Notun 151 number.
yes 696 is not there lordship
It is there. Purana 65 Notun
303 that is 303 lordship
303 Miadi Pottar Purana 65 Notun 696 Dag.
66 that is 66 lordship not 696 that is 66 lordship
No, 696.
then new 698
We have a copy.
yes I have written from that
This is
copy itself
696.
here all 66 here before it all is mentioned lordship
696, I'll read it out. Tagore,
notun notun 698 dag
Kotha, do you Dag? Ek Kotha Iman Losa.
1 বিঘা 1 কথা 10 লেচাৰ আধা ভাগ 4 কথা 6.5 লেচা so lordship entire land as per statement made in the plan lordship paragraph 3 and
66 no, 696
Yes.
Dag.
698
66 no, 698 Dag.
yes 696 is not there
It is there. Hey, to dekha diyechi, I think you have wrong. It is 698.
it is silent lordship as per statement made in paragraph 3 entire land 2 bigha 4 kotha 5 if lesa under dag number 696 and 698 here the portion of Phaguni Sutia and the portion of Haradi Sutia from same land lordship here if in the year 1971
You read it, once more you read it.
696 65 not one 696 that is there lordship which portion was sell out that must be specific lordship the 4 boundary is not there now if your lordship kindly peruse the schedule of exhibit schedule B of the plan lordship schedule B I will conclude within 4 or 5 minutes the north part schedule B north part remaining part of the land 698 occupied by Pekon Beg. Pekon Beg is another name of Mirza Beg lordship. So according to them, in the northern side, in remaining part of the land is under the possession of Beg family lordship. So from the planned as well as lordship from the schedule and all cross examination. It is admitted position, lordship. In earlier, in present suit also, the plaintiff has challenged the cell deed of the plaintiff, although deed number is not specifically mentioned. To challenge the cell deed, lordship, who will be necessary party? So necessary must be on a Sorodi Sutia legal heir, he himself, lordship. For seeking a decree of declaration or seeking cancellation of my cell deed, lordship, he himself is the necessary party. My humble and respectful submission, lordship, plaintiff is stopped from challenging my cell deed since same was executed through his mother to Lomthai to Niren Soikia. And here the plaintiff projected a case only that his intention, actual intention is apparent from paragraph 8 itself, lordship. So definitely after purchasing that suit land, lordship, the land under DAG number 698, in view of cell deed number executed in the year 1961, the defendant side categorically mutated his name in the year 1965 itself. Separate patta was also issued, and they came to know about issuance of patta from their own exhibit 3. It is apparent in the year 1983, lordship, and disposition in the year, lordship, 1980, and suit was instituted in the year 1999. Lordship, their suit definitely barred by limitation, and since they are only aggrieved with that mutation as well as issuance of patta, lordship, that exactly suit is barred under article regulation 154. And here my learned senior counsel submitted that no point of determination. Here, if your lordship, that judgment is not with me, 1997 Supreme Court, Kaluram. And another is there 2024 SP Srivastava. 1997 Kaluram.
Yeah.
I will place, lordship.
1997 SC.
1997 Supreme Court, Kaluram versus Saran Singh.
Page 1997 SC.
SC, the judgment is not with me.
1997 SC page.
I will provide page
Kaluram
number.
versus Saran
And
Singh.
another, lordship, in 1924 recent judgment of Honorable Supreme Court, SP Srivastava. In both judgment, lordship, it is categorically held that normally learned trial court issue frame issue on the basis of facts. Issue cannot frame on law point, lordship. That is why it is duty of the first appellate court to frame point of determination, to consider both law and facts. Here in this case, this case is totally exceptional, lordship. The learned first appellate court categorically decided maintainability issue under regulation 154 as well as 65 of limitation act. Here by deciding all the issues separately. Here in this particular case, your honor, point of determination is not at all required, and other various judgment that is there, non-framing of point of determination is not fatal, lordship. If first appellate court, being court of facts and law, decides all facts and materials available in the case record.
Okay.
That is not fatal.
Give the paragraphs also. Highlight the paragraphs also.
Yes, lordship, I will highlight. Otherwise, all other judgment I have relied, lordship, is with that written argument, lordship. So this is my humble and respectful submission. So judgment of first appellate court, lordship, well, as first appellate court decided all facts and materials, and there is no interference is required of your lordship.
Okay.
My lord, this is a second appeal, my lord. We cannot actually, my learned friend started from evidence of the, my lord, that is not required in my lord in second appeal. Second appeal, always we can argue only on the point of law, my lord, the substantial question of. So substantial question of law, my lord, regarding 154A, my lord, already I have placed the judgment, my lord, heavily relied by the learned trial court, that 154, my lord, there is no longer a good law now, my lord, there is revenue that is barred. My lord, all the latest, even latest law, that there is civil suit is no bar. Civil suit is no bar, my lord. Even, my lord, especially when there is a complicated question of law, question of title, then there is, my lord, civil court is, my lord, appropriate court, that is the full bench judgment of our high court. I have placed my, I given the judgment, my lord, and that way. And regarding, my lord, my learned friend says, my lord, that made a submission that, my lord, point of determination is not required. But I don't know, but law, as per law, it is required. Section is, it says, my lord. So your lordship kindly see that law point of determination always based on the ground taken in the appeal, my lord. In ground taken in the appeal, if your lordship may go by the memo of appeal, my lord, there is no, my lord, not a single ground regarding, my lord, limitation. Only 154, my lord, they have said. Your lordship kindly see the memo of appeal in the record, but it is not with me, my lord. But I have gone through it, my lord. There is no question of 64, 64 of the, my lord, Limitation Act, my lord. In the title appeal, my lord. So my submission before your lordship is that the substantial question of law which was formed by the court, my lord, these are appropriate, my lord, and my lord, in point of determination also, my lord, that is there, my lord, that substantial question of law also there, my lord. So, my lord, in the light of the judgment which I have placed before your lordship, my lord, there is a very well.
Judgments you haven't placed, then you.
My lord, I will give you the judgment. With copy and, my lord, highlighted the all the.
After 2 judgments, you have given 1 judgment, Supreme Court judgment I have.
My lord. So other 2, my lord, I will give him. Our High Court, my lord, didn't invent full bench judgment, my lord. There's a reference made to the, my lord, regarding that particular point, my lord.
Okay.
Tomorrow I will give him, my lord.
Can you give us the item number?
Item number 18.
Our learned senior
TJ.
counsel, Mr. TJ Mohanta, for the appellant and learned counsel. Oh, 9, put here more,
It's a very long pending case. That's why I don't like to take, my lord, adjournment from, my lord.
Yes,
It's a
yes.
2008 matter. It is our duty, my lord. That's, my lord.
Yes, yes. Actually, if you go through the, I don't know, I have not taken the statements. If you go by the statements, it is of course, from the AI.